notice to the other side.
দিদি এটা বন্ধ করে দিতে বলো, এটা বন্ধ। Yes,
Extension of interim order.
upon notice.
Notice.
Did notice, my lord, for listing my lord has directed me to this matter appear on 8th January, but did not appear, my lord. My lord, matter is most
Upon
urgent.
notice.
Upon notice, my I have served all the respondents, my.
My lord, may I permitted to mention, my lord, for hearing matter that the condition is premises condition is very bad, and the premises could not repaired again. An affidavit has been exchanged both the parties.
Affidavits are complete.
Yes, my lord. Both a letter is also given.
Upon notice.
Yes, ma'am.
Give the number.
Lordship, upon notice, Lordship, this matter is a municipal matter. For that reason, on the last day, your Lordship will find that your Lordship doesn't have determination to hear this matter. So this matter needs to be placed in the appropriate bench. For that, release of this matter is necessary for this.
What is the matter about?
It is a municipality matter of illegal
Right.
construction. has been done.
My lord, may we
I
permit?
mentioned upon notice to the other side.
My lord, may I be permitted to mention one matter, my lord, for upgradation, my lord. Item number 260, 2 days list. Because this is very urgent, because my client get the patta, but private respondent illegally trying to encroach that property. Therefore, it is very urgent, my lord. Already served the notice.
Upon notice.
Yes, my lord.
Give the
And I permitted to mention one matter. This matter was acted on yesterday. Due to my inconvenience, if Lordship kindly recall, on Monday at the time of rising, I mentioned, my lord, that so that the matter can be taken up on Wednesday. The Lordship asked me to send my junior. He prayed for time. But the matter is fixed on 26th of February. I don't have any problem on that regard. The interim order is expiring today, my lord. Let the matter appear under the heading extension of interim order. And I have given notice to the other side. Yes, my lord.
কালকে extension of interim order. To be mentioned, extension of interim order. কালকে।
Extremely grateful to you.
Application from the heavy company irrigation department illegally are encroached on land
Are you mentioning upon notice? Give the number.
With notice, my lord, I am mentioning for analogous matter. My lord, this is almost, my lord, the matter has been mentioned by my landed junior.
Give the number.
Lordship, may I be permitted to mention one matter for your Lordship for one correction of your Lordship's order dated 8th of January 2024, your Lordship.
Upon notice.
Your Lordship, we are the petitioner, your Lordship.
Are you mentioning upon notice to the other side?
No, your Lordship.
To do that. Right?
Okay.
Mention upon notice, I'll take it up.
Obliged, your Lordship.
I seek my lord's kind leave to mention, my lord. I am mentioning upon notice, my lord. Petitioner's tea estate has been, a portion of tea estate has been acquired without paying fair compensation to the petitioner. They went ahead with to cut the tea bushes and all without paying any compensation. My lord, I am mentioning upon notice.
Your
Lordship,
may I-
Lordship, that original side matter, Lordship, that item number 2 at 2 p.m. Other side advocate is also here.
Election petition.
Election petition, my lord, that
What
pray,
happened?
praying for adjournment today, my lord.
Why?
My lord, that my kindly consider,
Cross-examination, sir.
my lord,
Going on for such a long time.
my lord. We both are here, my lord. That's we agreed on it. Yes, my lord. On 22nd, both we are.
You're not there now. So come back at 2 p.m. please. I'll fix the date.
I'm grateful, my lord. Grateful.
Your Lordship, may I have the liberty to mention a matter for inclusion in the list as application? It's a Section 51 motor vehicle challenging Section 51 of Motor Vehicles Act. So my application is for dismissal of the read petition.
Are you mentioning upon notice to the other?
Yes, yes.
Give the number.
But on content application.
Your lordship,
Didi, to be mentioned in Rakhun.
your lordship, may I be permitted to mention one matter?
Content.
Fresh contempt, new contempt.
Is it pending? It is pending.
It's pending. Have you served the other side?
Or I cannot stop the contender has been transferred from other court. New contender has come. Let it appear as to be mentioned. I have to take leave of the court and have to.
Your lordship, may I be permitted?
এইটা বললো যে ডিসমিসাল চাইছে। সেই জন্যই হয়তো রিলিজ চাইছে। বললেন মনে হচ্ছে
Your Honor, may I be permitted to mention one matter? It's a combined marxist group one matter for upgradation. Your lordship, I served
upon the state
Your
responding. Your Lordship, my petitioner's land was acquired by the respondent authority, but no compensation was given, and Your Lordship, no plot was given to the
We have
petitioner.
petition.
Yes. Or like
Yes, Jalpaiguri Circuit Bench.
My lord, kindly consider the earlier order passed by my lord.
Is it?
My lord, I have completed the work. My lord, lordship, my lord, directed them to dispose of the matter and also to
You are
ensure.
appearing for the alleged contender?
No, my lord, we are appearing for the petition.
Petitioner. Who is appearing for the alleged contender?
My lord, lordship, kindly consider the order and how, in which way they have flouted the order. They have given the hearing stating that as and when the fund will be available, the payment will be made. This is of in the year, my lord, 2013. Since 2013, my payment has been withheld. Lordship, kindly consider this
Who
order.
is appearing for the contender?
Okay,
Mr. Shonam Bhattacharya, Mr. Tirthankar Mukherjee, Ms. Madhurima Sarkar. They are the councils appearing for the contender.
করেছিল যে কিনা আমি ট্রান্সফার হয়ে গেছিলাম আমরা নেই স্যার
Good day. Lordship, kindly consider this
They are
order.
in the panel.
ইয়েস বলা
Mr.
Lord.
Shonam Bhattacharya, Tirthankar Mukherjee, Madhurima Sarkar.
Tirthankar তো আছে। Huh?
চিনি না তো
My lord, may I serve, my lord, upon Mr.
They are not in the panel.
মালা রাইট মালা নিউ প্যানেল মালা
Because 20th December order, they were there. They were present.
তাহলে আছে তারা
So there is no change of panel after 20th December.
no no
Are they from Jalpaiguri? These councils.
possibly they are not known to us my lord
They are not known to you, yes. Madhurima Sarkar.
Last occasion, my lord, they appear.
লাগবে
Let there be a show cause as to why rule shall not be issued. It's a contempt application, they cannot be so casual. None appears for the alleged contemners.
ওইটা হারিয়ে যাবে তো এরকম করে বই রাখলে হয় কেন চলে যাবে
Paragraph, the second alleged contender is directed to show cause
এটা দেওয়ার দরকার নেই।
as to why rule of contempt shall not be issued against him for non-compliance of the order of this court. Paragraph, the department is directed to serve notice upon the alleged contemner and submit a report to that effect on the adjourned date. Paragraph, let the matter appear under the same heading on 20th February. Sufficient time for service.
আবার সার্কিট বেঞ্চ আছে নাকি বড় সার্কিট বেঞ্চ
Next, case list.
Lord, I appear for the state respondent, my lord. At my instance, this matter has come up before your lordship, my lord. I had mentioned the matter upon notice. Now, my lord, in this writ petition, the petitioners have challenged the show cause notice as well as the steps taken in furtherance of the show cause notice for cancellation of the lease deed. Now, my lord, my instructions from the specific instructions from the department that we are withdrawing the show cause notice. My lord, this is my instruction. Let us hear it.
Mr. Khan, you are appearing for the.
Lord, I am opposing this because I tell you, lordship, why. I'll just complete my learned friend will have his. My lord, now, my lord, if your lordship kindly sees the prayers in the writ petition at page 28. At page 28.
11th August 2021 notice.
And 5th September 2022. If your lordship kindly sees my communication. Lord, both of which we are withdrawing. Now, my lord. Now, my lord.
Council of High Secondary.
Yes.
On 26th of July 2023, My lord, I have, my lord, mentioned the matter before your lordship on 27th of July. So prior to that, on 26th of July, I have sent a mail to the learned counsel for the petitioner saying that I'm going to mention the matter before your lordship and saying that I have got instructions to withdraw the writ petition in view of this particular notices. My lord, there is inadvertent error in that notice. That is why the fresh notice has been taken out. Those, if your lordship kindly sees, in that notice, the error was show cause notice is dated 11th September 2021, though it
The
ought
date
to be
is wrongly stated.
and thereafter, my lord, this memo number 3911 dated 11th August, this is also not there. So this was, and granting liberty we had sought for in, I am not into that now. But I have got fresh instructions that we are withdrawing both the show cause notices. So nothing remains, no cause of action remains in the writ petition, subject to correction, my lord.
Kindly
Let
see.
us hear the,
My
yes.
lord, first of all, my lord, it's a very surprising that we have not been served with the fresh notice. No copy has been handed over to us. And my lord, all on a sudden, he is submitting a paper saying that my.
I can get
This is
here,
a-
no, my lord, sir.
this is the, I don't know that, my lord,
I don't
how they can
better-
say on the basis of this that writ application is infructuous. My lord, then writ application should be allowed on the basis of this. Kindly allow my writ petition that saying that the
Allowed on the basis of what? You have challenged both the memo and the notice.
So, my lord,
They are being withdrawn.
so, my lord, my writ application becomes infructuous.
Yes.
Kindly see
It becomes
what he is
infructuous.
submitting, that my writ application has become infructuous because till date now, my lord, just now I have been served with this. Prior to service of this one, it cannot be said that writ application becomes infructuous.
Mr. Pan, you are being technical.
Now, my lord, kindly see, my lord, kindly see, my lord, just now I have received this. Can you take it up any other day?
The court will pass an order.
I'm grateful.
No use keeping it pending
Well,
any
very
further.
well. My lord, then, my lord, only the writ application is disposed of on the basis of this.
On the basis of this, it becomes infructuous, sir.
But my
You
lord,
have
kindly
challenged
see,
the two
kindly,
notices which are
kindly,
being
kindly
withdrawn.
see what is their language. Now I therefore I am direct to request to kindly pray before this honorable court at the Calcutta allowing this department to withdraw the so cause notice. My lord,
Now, why will the court
Yes.
allow the
No, my
department?
lord, my
That
lord,
is
since
exactly
the
what
writ
I'm on.
petition is pending before your lordship, my lord, I could not have withdrawn the show cause notice, my lord. Your lordship may pass any order. I am going to withdraw the show cause notice, but during the
This-
pendency
Withdrawal
of the,
of show cause notice has nothing to
sir,
do
I do
with
not want
pendency
to
of
give
the
rise, but
petition.
I do not want to give rise to a new cause of action because the writ petition was pending before your lordship, subject to correction, my lord. So, what my specific instruction that we are withdrawing the show cause, your lordship may kindly record that. Your lordship may
My lord,
kindly
his
record that.
instruction is something else and the relator is something
record
else.
his submission.
On this basis
My
of
lord,
this,
friend,
this
my lord,
this
my lord,
cannot be this
extending
cannot be
the
withdrawn.
entire issue.
No, I am not extending. You have not filed your affidavit
Please,
till
please
today.
hold.
The show cause notice dated 11th August 2021 and the memo dated 5th September 2022 are assailed in the writ petition. Paragraph. Learned counsel for the state respondents submits that both the notice and the memo shall be withdrawn by the authority by tomorrow. By tomorrow. Paragraph. A letter issued by the Additional Secretary to the Government of West Bengal, comma, Department of Land and Land Reforms and Refugee Relief and Rehabilitation Department, comma, Department, on 31st January 2024, in this regard, is taken on record. Paragraph. In view of the above, comma, nothing further remains to be adjudicated in the writ petition,
Yes.
and the same is accordingly disposed of.
Well, let the written instruction be kept with
Urgent,
her.
yes, urgent certified percent, huh? Cost with the urgent certified percent.
I'm grateful.
Next.
My lord, if they don't, then my lord, writ application, my writ application will get live. Kindly add that. If they don't, my lord, I have a very.
But I will. By today only, I am hopeful by today only it will be done.
Next.
My lord, in this matter, my lord, I am for the state. I appear on behalf of the contender number 1. I miss the list, my lord. So, my lord, I pray one
To miss the list.
and he is.
My lord, I appear
for
for 2 and 3, my lord, we are appear 2 and 3. But we are ready for an affidavit. Lord, as per the records, content is not lies. The suppression of the facts in the writ petition itself.
So have you filed a recall application?
No, I am filed the
Never
affidavit
challenged, my lord,
in the
till date.
contempt application, since the contempt is not lie at all. That is, my lord,
Why there is no violation of the order?
no violation of the order. What's an allegation that has been done long back before the filing read application? In terms of the government order, already construction is done.
Of a contempt application is very limited, as you are aware.
That's true.
So has the order under contempt been complied with
Under
or not?
contempt, they have alleged, they have alleged after the order, construction is going on. But that is not the facts. Construction is held long back before filing the read application.
My lord, may I appear for the applicant, my lord? I appear for the applicant, my lord. May I just appraise your lordship, my lord? My lord, we had challenged a tender pursuant to which, my lord, your lordship was pleased to, my lord, call for a notice, and, my lord, your lordship was also pleased to, my lord, stay all further construction with respect to the
Yes.
plot in question. Now, my lord, subsequent to, my lord, the interim order being passed, my lord, we had communicated to all concerned. Now, my lord, it's been 6-7 months thereafter. My lord, construction has been going on. Your lordship's order under challenge, my lord, has never been, my lord, assailed before any division bench or, my lord, any recall applications were sought for, which is why, my lord, the contempt application
The petition is pending.
is pending, my lord. An interim order is still subsisting. Your lordship on the last occasion had also
That's true.
extended the
What's interim order?
Now, my lord, may I just indicate one aspect, my lord? The 3 alleged contemners, my lord, were erroneously, my lord, the names were erroneously pointed out, which is why your lordship on the last occasion had granted me leave, my lord, to correct the cost title, and we have corrected the cost title and we have served fresh copies. Now, my lord, if these alleged contemners, my lord, today before your lordships are of the stand that your lordship's order has not been flouted, my lord, may I just request this? Let them put that on affidavit, because I have videographic footage indicating, my lord, that these people were on the plot in question itself. And, my lord, they were facilitating the construction. My lord, to say that, my lord, the construction was never carried out after, my lord, your lordship's order, my lord, is entirely baseless.
Or the last occasion, we have all seen the photographs.
My lord,
That was the
these are only some of
engaged
the photographs.
for the
Because
purpose of
6 months,
cleaning.
my lord, every day, my lord, I had specifically instructed my client to go, my lord, click photographs, my lord, because my facility is just on the adjoining plot. So it's very easy for me to access it, click photographs, get video footages. I have all of that. And I can place that before your lordship. The only reason I did not is because it would have become voluminous. But if they today say that, my lord, no construction were carried out, let them put it on an affidavit. It will be easier for me to, my lord, come before your lordship and say that a perjury has happened.
Yes, affidavit ready. We have ready.
Very well, my lord. Let them serve copies. I'll, my lord, take necessary.
We have
But, my lord,
already
may
ready
I,
affidavit.
may I just indicate, my lord,
The one indulgence, my lord, only things for a moment. Your lordship is passed in order, whatever may be. My lord, the scene is the read application is pending. My lord, let the read application be decided in the merit. And, my lord, the giving the chance, my lord, file the affidavit. Otherwise, matter cannot be disposed.
They will have to first.
Order, my lord, interim order. Your lordship, is there something is going on behind the back? If your lordship kindly see the read petition, paragraph, page 52, it's itself clear.
my lord, we are not shying away from the final hearing.
Respondent numbers 1 and
Two and
contender numbers 1 and 3.
My lord, one is my lord BLRO. BLRO to one.
BLRO, sir.
BLRO, my lord.
BLRO, my lord, and the
we are 2 and 3.
BLRO, my lord. No, my lord. BLRO, my lord, and the executive engineer.
Executive officer, Sahabati.
One is, my lord, the BLRO, the contempt,
And 2 is the Gram Panchayat.
Gram Pradhan, my lord.
My lord, am I audible to your lordship, lord?
So these appear in
What BLRO?
One.
2 and 3. You are
2 and
appearing.
3 with.
My lord, I handed over the property to the new incumbent, my lord, who is the authority.
Panchayat authority.
Panchayat development.
Lord, itself, my lord, the
My lord, he
lordship.
filed an application. He filed an application for lease, my lord. That was, my lord, not in favor of it. My lord, we, for the sake of our interest, my lord, government interest, my lord, we handed over, give the lease to another, that is the respondents. Now there is a conflict. As we have not issue any lease in favor of the long-term lease in favor
No,
of.
that's fine, but there was an interim order passed by this.
Yes,
court.
my
That
lord.
should have been
That
completed.
Yes, my lord.
That is, my lord, we are like trying to say, my lord, after the order, no construction is carried on. That construction has been held long back. Long back. They have
Simply not
picture only for the person engaged for the cleaning, not for the purpose of construction. And your lordship kindly see the repetition page 52. Itself clear. Page 52, annexure P11.
in the read
You
application.
are filing two separate affidavits. Let's go through the affidavits
shall.
and come back.
Yes, my lord.
And you will come back with your affidavit on the next.
Yes, my lord. On the next date, my
No,
lord.
so my respectful submission, since the read application is filed, my lord, the giving chance to file the affidavit of the read application so that the read application can be decided.
Let
I
us
am not,
decide-
I am
Let
not,
us decide the contempt. Let us
that's
see
true, along with,
whether
along
the
with.
alleged contemners remain outside or inside.
No,
After
no,
that, the writ petition.
that is another thing, my lord. So the read application, we are making the parties, so giving a chance to file the affidavit, short affidavits, let the matter be decided.
Well, we
All
are
the
not
matter.
shying away, but just because my learned
And
senior
nobody
friend
will
is
prejudice.
confident on the writ petition does not necessarily mean that your lordship's order should be flouted. Well, it's
No,
been
that's
6
true,
months
that
now.
will be-
Absolutely, my lord.
That will be considered at all, along with. They can be decided all the things. I am not out of the court.
Affidavits submitted on behalf of alleged contemners number
Copy.
2 and 3
Which
are
petition?
taken on record. Paragraph learned counsel for the alleged contemner number 1 also seeks to use an affidavit in this matter. Paragraph let the matter appear under the same heading on
My lord, my lord,
21st February.
my lord, the only one thing, my lord. I have not, nobody will be prejudiced. We file the affidavit in the amended application. Let both the matter be can be decided.
Your lordship, my lord, had directed filing of reports. It's on record. We have used an
Oh,
exception.
yes, I filed the affidavits. Two
Affidavits are not required at all.
affidavit of the read application.
My lord,
Read
it
application.
never appeared before your lordship in the
That's
writ
true.
proceeding. And
Nobody
now
will
they have
prejudice.
come before your lordship, my lord, they want to, and they are urging, my lord, that an affidavit. If they want to file an affidavit, I don't mind, but my lord, this,
Necessary at all.
it's not.
Of course,
And
of
it is the state
From the
government
records-
who should have taken a
Been
stand.
filed and exception has been used.
No, reports, my lord, report, I cannot, my lord, the report, Panchayat cannot file the report. Panchayat can file the opinion opposition. That can be decided in the main deed application at all,
You're appearing for 3 also.
of course.
3 is a state authority.
Then your lordship
Who
kindly,
can file a report?
then your lordship kindly one line, my lord, the file the affidavit in, file the report, that will be treated as opinion opposition. That will be treated as an opposition. Otherwise, main deed application going behind the back, that is, my lord, things, my lord, contempt application, lordship can decide on contempt application along with. Nobody will prejudice if the read application decided in the merit.
Mr. They has filed a report in the form of an
Yes,
affidavit in
yes,
the.
yes.
That is their part.
And we have
But
used an
we part, my
exception.
lord, some things is, my lord, required to be established in the main deed application. So nobody will prejudice. I file the opinion opposition.
Well, it's
matter is
not
pending
possible
before
for the
lordship.
panchayat, my lord, to take a stand contrary or in furtherance of the state authorities.
The state.
Now they have used it.
For that affidavit, we can file affidavit. Nobody will prejudice.
We are made parties. We can.
Since we are making the parties.
Very well, let him come back on affidavits in that case.
Yes.
Well, in the meantime, let us serve a copy upon me
course,
because I
course.
haven't
Yes,
received.
Of course.
You know.
Contempt 21st হয়ে গেল WPA তে order করুন learned counsel for your respondent numbers
Two and
in the writ petition.
7 and 8.
7 and 8.
7 and 8. Main deed application 7 and 8.
7 and 8 seeks to use an affidavit in opposition in this matter. Paragraph affidavit in opposition be filed within 2 weeks.
Weeks.
Within 2 weeks from date, stop affidavit in reply, comma, if any, comma, be filed within a week thereafter.
A matter, it will appear on.
It is already, I have stated 21st February.
Oh,
Well, the affidavit with respect to the contempt application.
reply.
The report is already there, yes. Only 7 and 8 wants to file.
They file the report only.
Well, the affidavit which has been filed before your lordship today with respect to the contempt application, let a copy be served because we'll have to.
You have not served a copy of the affidavit?
And just now, just
I could have practice করছি
Serve a copy
of course.
বারবার বলছো কেন দিচ্ছি
আরে বের করছি।
হাতে রয়েছে দিয়ে দাও হাতে রয়েছে দিচ্ছি
রিসিভ করে না।
দিয়ে দাও এক্ষুনি
হুম।
বারে বারে এটা procedure হচ্ছে
Sir,
আগে
one
দিয়ে দিবা
minute.
দিয়ে তারপর লোককে দিতে হবে।
আজকে একটা সপ্তাহ, So let it appear on the 28th of February,
28th.
2 weeks and 1 week.
Well,
28.
Another copy already sat.
Next.
যদি এটা দেবে
Yes, item 4.
আমি ওকে দিই আইটেম 4 এটা আমার কাছে চেষ্টা হ্যাঁ তো তোমাকে আমাকে এখন দিও না পরে পাঠিয়ে দিও আমি
এই প্রথম একটা বেরোলো যেটাতে আপনি না। 2024,
Item 4.
you are appearing.
Yes, both are appearing.
I am not the applicant, my lord. I am the
I'll
respondent.
correct the order. Your 23rd November is recorded in the order. Though I had stated the date, I think, in the open court. Are you ready, both the parties?
My lord,
In the
this is
said-
a review arising
said
out
order,
of a
give me a
repetition.
minute. The said order. In the said order, 23rd November 2023 be read as. আজকের যে দিন। First,
Order dated 8/6/2023.
the department is directed to incorporate necessary correction accordingly. This order is treated as part of the order transfer. Yes, so we can take up the matter both the sides of it.
Order impugned in the review application. This is
You are appearing, you are the petitioner.
I am the respondent, my lord.
This one a number?
Respondent, my lord, central warehouse. Respond number
Yes.
my lord, first,
34.
my lord, take up my affidavit service.
Yeah, please. You are appearing for respondent number?
3 and 4.
This is a review application, is it?
Yes, my lord.
Arising out of a writ petition dismissed.
Review has been registered as CAN 1. You are appearing for respondent numbers?
3 and 4.
3 and 4. What about the other respondents?
Well, other respondent not contested. One is police authority, another Minister of Food, and another was Port Trust. I respondent 5. He also appeared on the last occasion when my lord passed the order. Today I served upon the Port Trust authority, but this is my appeal service.
You have to serve all the respondents?
Yes, my lord, I served.
My lord, perhaps we are the only interested respondent in the review application.
In the matter?
Yes, ma'am.
Court is also interested.
No, but service should be affected, isn't it?
Yes, ma'am. Absolutely.
Port of Calcutta has been served.
Port Trust is respondent number 5.
Ministry of Food, that,
There is respondent number 2.
yes, the.
We always served upon them, but they don't appear. Only Port Trust respondent 5 appeared, and 2 and 3 and 4 appeared. 1, 3, 4.
Yes, what is the review about?
My review is, my lord, well, kindly take up the my writ petition, the annexure page 1881, main writ application. Well, main writ petition, my lord. It is 4821 of 2020.
This order was passed in your presence
Yes, my lord.
upon hearing your submission.
Yes, my lord.
What is your
On
ground?
both sides submission.
What is your
That is
ground?
not satisfying. We'll take up the writ petition, page 1881.
What my learned
Oh,
friend
Baba.
seeks is rehearing of the writ petition on merit once again.
Well, ask him to
What is-
kindly make my submission. Thereafter, I am the petitioner.
1881. Yes,
1881.
yes.
Now see the last part of this is the order impugned in the writ petition. Is the order passed by SS officer. This is the part of the order. At page 80, my lord, see the last paragraph. My lord got it. Accordingly, I signed the formal order of eviction under 5 as act as per rule made thereunder 15 days time to vacate, etc. Now, my lord, this is one part of the order. And my lord, turn to page 81.
Yes.
Next page. See the next, second paragraph. It is my considered view that a sum of rupees 75,64,000, etc. for the period from 31/12/18 up to it is due recoverable. When this petition is heard by my lord, on eviction part was pressed by them, the factory has been vacated, so it's redundant. But this was not pointed out. It is my mistake, court's mistake, and their mistake also. There were two parts of the order. The second part has not been implemented. This is on running. Therefore, this reason, this is present for the sake of argument, it is to be hard. Even
Amount is due and recoverable from you.
they say, they
According to
claim,
them, yes.
they claim, but my claim is that I am recoverable only 7 lakhs from them. We are not entitled to pay any debt. Rather, it is recoverable from them, so it was 7 lakhs. So this part of the, it has to be hard.
So if it is not paid by you, it is for them to take necessary steps?
No. I might say that we are not liable to pay at all. This is the blanket expert order passed by the estate officer.
It's an appealable order.
Can you see?
It's an appealable order which has not been appealed. A writ petition has been preferred in the shape of an appeal, my lord. There is a statutory remedy that has not been availed of. That was considered before you, the submissions were made. It was considered by your lordship while passing the order which is under review.
My concern view is that in 100 cases, at least, the established order was challenged in the High Court, because for the non-applying on principle of natural justice. In this case also, on 31-1 notice was issued by voluminous application, every 40 pages. File come written statement on 31-120. Served on 15-1, date was fixed on 13-1. The 13-1 was happened what holiday of our source, etc. We request whether he will come, taken back or not. Establisher came back from office, well, wait, I am seeing. After a few minutes, he said, you go back. Another phase is fixed for hearing when you will come back. All this thing, all this thing. I'm only, my pain is that the matter is not being hard on merit for the long, even a long end of hour.
Well, 3 rounds of litigation.
Not only that, this
first petition by us,
kindly,
all these were canvassed there.
Division bench also.
None were considered.
Also
that was taken up in an appeal.
Directed my lord to
the division bench also did not consider the contentions of
the I also see my grounds taken in review application.
The writ petition here
always all matters
was also dismissed on merit.
Being frustrated when it comes on merit.
The scope of review is very limited, and I do not find any ground for review of the order. It was passed in your presence upon hearing your submission.
My lord, this is not seen by my lord. That is error apparent. Not only that, my lord, take up the, my lord, let me consider the grounds in the application. First thing, take up the grounds of the application. Give me some chance. First ground taken, the fact that the Honorable Court overlooked to observe that the order of estate officer, ground 1. Estate officer was not fully implemented, which was the error apparent face of the record, as the order of estate officer contained two parts of the order. One was to vacate the property and second was for recovery of the area amount. Second ground. For that, the Honorable Court erred in considering the report in the form of affidavit as to present status of the property was filed by the Central Land Corporation as well, which was not actually done.
Can you write this in a review application?
Can you
write this in a review application?
Yes, my lord, these all are. No, yes. These all
submission against this court before this court.
No. My lord asked them to give the present report, but they did not give present report. What is status of the property?
The Honorable Court erred in considering. When do you use this sentence, this language? When it's an appeal before the higher forum, not before the same court.
My lord, then with the second part, second part of the order about the amount.
I dismiss. This is only for your language, nothing else.
Which language, my lord?
The Honorable Court erred in holding.
Consent report. It is actually true, my lord. Nothing, my lord. My lord asked them to file.
This court, you cannot put it before this court.
No, with the bona fide error, my lord. Bona fide. No, my lord overlooked this thing that they file not the proper affidavit which my lord asked, but my lord was presented. This is the affidavit. My lord asked them to file presented. See the order.
Previous order. This point was not taken.
Previous order.
Afterthought, my lord, to stall a recovery proceeding.
No, this language is derogatory.
Absolutely, my lord. Absolutely.
You cannot use this language in a review application.
My lord, see. For a moment, my lord, kindly come to.
I'm sorry. Nothing more is required. You can prefer an appeal. Affidavit of service. None appears for respondent numbers
1, 3, and 4.
You are for 3 and 4.
1, 3, and
1,
4.
3 and 4. 2, 5 and 6. Despite service. Paragraph heard by the counsels for the parties. Paragraph, the applicant petitioner has sought review of the order passed by this court on 8th June 2023 on the ground that this court overlooked to observe the order of the estate officer in its entirety and also erred in considering the report, erred in considering that the report in the form of affidavit as to the present status of the property filed by the Central Warehousing Corporation did not depict the actual status. Several other grounds for review have been taken by the petitioner, applicant petitioner, which are on merits of the writ petition. Stop. Paragraph. The scope of review of a matter, of a writ petition, or for that matter, any case disposed of by a court is limited. The order under review was passed upon hearing the petitioner and the respondents, and it was admitted by the parties that the said order was already implemented and possession of the storage space in question was handed over to the Kolkata Port Trust by Central Warehousing Corporation.
This was not admitted by us.
Paragraph. Learned counsel, since the petitioner, the applicant petitioner submits that the review application has been filed due to errors made by this court, comma, the order under review may be appealed against by the petitioner. Stop. This court cannot rehear the writ petition on merits in the garb of a review application, in the garb of a review. Paragraph in view of the above, the review application being RVW 149 of 2023 is dismissed. There shall, however, be no arrest to costs as in certified post. You do not take before the same court that the court has erred in law.
No, error commits maybe bona fide because court believed him. His sufficiency. That is the thing.
Be more
But
careful about your language. Next.
Apology, Chair. No. My lord, item 5, 6, and 7, my lord, the three analogous
the
matters.
respondent.
And my lord, 20th December 2023 and my lord, on 29th of January, my lord was pleased to hear out the matters at length. And my lord, it was fallen from your lordships after placing the
Last day, my learned friend was completed his submission. I am replying to that, but due to the, my lord, 11:30 matters, my lord, I could not be able to complete my
12:30,
argument. For
12:30.
this reason, matter is taking
I-
fixed as a top, my lord.
Again, my lord, just I want to sum up my some arguments because of to refresh your lordships.
Yes, Mr. Ghosh has also made his submission. I have recorded the.
I am also started my submission, but due to 12:30 matter, I could not be completed. For this reason, my lord, your lordship,
I have
a
taken a note
top
of it.
matter is fixed at top, my lord, today.
My lord, in this case, my lord, the petitioners are the licensees under the respondents.
Bharodan naki? এই অমৃতা তো দিদি
Most unfortunate part in this matter is, my lord, the responsible railway officer affirmed a false affidavit before this court. Why I am submitting this? From perusal of the report, I found the name mentioned in the writ application, the petitioners, they are the licensee.
Yes.
They are the licensee. They have paid up to date their occupation fees till the date of issuing of the notice. And in one case, plot number 1009, in the report they have stated they did not find any documents. That particular plot was reserved for the military personnel, those who were died during the war. And Jila Sainik Board, my lord, allotted the said particular plot to the petitioner herein, one of the petitioner herein. And he also paid money sheet I have annexed in the writ application till 2020-23.
23.
20. Till the, my lord, the financial year. And after issuance of the notice, my lord, 22nd March 2023, they did not any occupation charges from us. So, my lord, this is as a blatant lie to, my lord, suppress the truth before this honorable court by way of an affidavit. I have annexed my allotment letter. I have annexed my occupation charges and, my lord, the allotment. What is the crux of the matter is, my lord? All the petitioners are very poor persons and met the railway board in the year 1979. Considering the unemployment, my lord, they have decided to allot small portion of plot. Well, it is 5 feet by 5 feet, 10 feet by 15 feet, 20 by 15 feet. The petitioners share it. In the year 79, they have allotted the plot with the condition that they will construct the shop as per their specification and the expense with by the petitioner. They have constructed their shop. They are carrying on a business 79 to maintain their livelihood. And several persons are all employed there. In the meantime, my lord, in the year 1997, suddenly, 31st December 1997, one notice was issued. You have to, my mentioning individual name was issued. You have to leave the plot, you have to hand over the plot to the railway authorities. We made representation to the authorities. And thereafter, my lord, we moved a writ application before this honorable court. And, my lord, kindly, I'm just, my lord, the
Notice was set aside on the earlier. Yes.
I'm coming to that, but just to show the.
You stated these facts on the earlier
My
occasion.
lord, well, kindly have a look to my representation. Well, the main mention in their representation, those who are the writ petitioner here, page 121. Once, my lord, to satisfy my learned friend, observation.
Yes, 121.
My lord, starts from page 21. This is my name. That time I was moved this application before this honorable. That time
121.
121.
Yes.
I moved this application. That time it was 9 years of practice in this court. But Noor Begum, number 1. Noor Begum is also second writ petition is the second item number 6 is the petitioner. In Appa Rao, Munilal, Lakhindar Mahanti, Snehanshu C is the petitioner here. Ram Maiti is the petitioner here. Nandolal is the petitioner. Dayanidhi Pradhan is the petitioner here. Bholalal Gupta, my lord. also petitioner. Rup Kumar also petitioner here. Ohimanyu Christie is a petitioner here. Prabhat Giri, son of the Prabhat Giri, has died recently. His son is petitioner. So, my lord, all the names mentioned in the writ application, that was, my lord, they moved earlier. But my learned friend says we are unauthorized occupant. By saying so, it's a very easy unauthorized occupant. Then, my lord, the relevant portion of the order is at page starts from page 4 orders I have annexed here. 4 writ application I has moved that time. My lord, starts from page 139. But on that day, my lord, at the time of moving up the application, it was observed by the Honorable Justice B.K. Gupta was there. How we will remove them, how we will take possession of the particular flat in a civilized country. Then, my lord, London advocate for the railway says, okay, we will not press this notice. Then, my lord, the middle portion of this, middle portion start and start. Mr. Bhattacharjee, the learned advocate for the petitioners, has no objection to this cause being adopted. Based upon the aforesaid submission, I dispose of the application. I dispose of the application finally and set aside the aforesaid impugned order, whereby the petitioners were called upon and directed to vacate the property in question. So this order was passed. Then, my lord, without an interruption, and then, my lord, starts from page 132. Page 132, my lord, file. They issued a notice upon us. The writ petitioners before your lordships. Prabhat Giri, Shipra Maiti is the first petitioner in this writ application. Noor Begum is the item number 6 is the petitioner. And Prabhat Giri, my lord, here. They directed me to deposit the license fee. We deposited the license fee. I have annexed all the license, my lord, fees, documents, occupation fees in the writ application. They, my lord, instead of license fee, they are written, my lord, occupation charges. That occupation charge is still not. I have placed to be your lordship's earlier occasion. My lord, all the 2020 to 23, my lord, have been annexed to the writ application. Now, my lord, the the second, how the plot will be allotted. That is also, my lord, their code is there. That total book, the book was my mistress. I have annexed the particular provision for allotment of shop. There is no time limit was mentioned. My lord, kindly have a, my lord, kindly take up my affidavit for exception to the report on affidavit filed by me. Affidavit.
You have filed 2 exceptions.
Oh, 3 exceptions
Three
is there.
exceptions,
3 exceptions is there.
You are referring to which of the exceptions?
My lord, referring, my lord, 10285. Exception. Exhaustive. Relevant.
এই একটার মধ্যে ঢুকে গেছে 10287 10286 পরের দুটো বলেছেন yes
got it, sir.
Exception, yes.
My lord, it will, my lord, the Code of Railway Engineering 1993 provides, my lord, the way, the manner they will allot the plot. Why they will allot the plot to the outsiders.
Page,
my lord, 14 at the bottom.
14.
Page 14.
Yes.
My lord, type copy is page 15. My lord, method of management. To enable management to be conducted on commercial lines, railway administration are permitted to grant to outsiders or other department under lease or license right and facilities in respect to available land for such purposes, whether or not connected with railway working as they will suitable. In this particular clause, this, my lord, the particular small plot of land was allotted to us. This is the origin. On the basis of this, my lord, they allotted the plot in the year 1979. And my lord, after, my lord, have placed, my lord, the notice, my lord, which have
Yes.
already considered by your lordships, and already, my lord, hold that this kind of notice is not tenable in the eye of law.
That
And-
order is at page,
My lord,
the earlier writ petition.
earlier repetition page order is start from 131. Starts from 133. Relevant portion is, my lord, all the names is mentioned there, those are the repetition are here. And, my lord, they issued a notice. Please deposit the license fee. We are carrying on, my lord, paying all the license fee. Starts from page 150. 150. This is another. So many orders is there. 4 writ applications.
150 is that same writ petition.
Same order. 4 orders, my lord, I have managed the writ application.
Yes, what
And
are
the
where are the
151 is
other
the
orders? This is one. Where are the other orders? The other 3
other 3 orders are also there.
page numbers.
My lord. My lord, you better, my lord, page 132. They are later.
No, the orders.
My lord,
Writ petition orders.
I'm page 139 starts from, my lord, page 133. Is that, my lord, the relevant is 139?
139 is the same order, 12th May order.
My lord. The same order, same 4 orders, same.
One earlier writ petition was there.
4 writ petition was there. 4 order was for similar order. Similar order was for 4 writ application. And that will also find, my lord will found it from page 132. After the order, they have, my lord,
Issued this notice.
well, the above mentioned DPA petitions are heard on 12/5/98 by the Honorable Justice V.K. Gupta of the Honorable High Court, Calcutta, in presence of the learned advocate appearing for both sides. Finding his lordship has been pleased to pass an order dated 12/5/98 inter alia, was the improved notices dated 31st December 1997, and debate was granted to the Railway Administration for recovery of possession charges, license, etc. in accordance with law. Pursuant to the Honorable High Court order, pursuant to the Honorable High Court, Calcutta said order, you are supposed to make payment of temporary license, occupation fees, etc. in respect of the railway plot or railway station Bogda area, but you have failed to deposit the license fee till date. In such, you are requested to make payment all license occupation fees. Accordingly, we have deposited the money till one of the issuance of the notice. And the notice we have challenged in the writ application is at page 151. And, my lord, I have also placed, my lord, why the railway board issued the circular, and there is a provision for, my lord, change of ownership. There is also a provisions they have enough. And, my lord, the petitioner number 1 here, SUVRA Maiti, my lord, kindly have a look to page 86. On the basis of the circular issued by the railway board, the name of the petition number was, my lord, will appear from their letter. They have accepted the change of ownership. There is a provision, my lord, because since 79, so many persons may be died, maybe, my lord, left the place. So, my lord, they have a provision to change of ownership. So, as per their notice, my lord, the petition number 1 here, the change of ownership was accorded. The relevant payment was made. His name was, and agreement was also executed in 2015. And that agreement, my lord, my learned earlier question says that there is no agreement, but agreement is there. And they himself, my lord,
my submission was no valid agreement is there.
It is their duty to execute.
Since it has expired, that was, it was not renewed.
No. My lord, they have referred it from the body of the petition also. They are, my lord, the report on affidavit filed by my learned friend, but at page 5. They have stated, my lord, in paragraph 55.
Yes.
In what manner? According to them, my lord, they have to issue 1 month notice. They have to issue. The administration shall suspension and determination of agreement by the president. The administration shall at any time and from time to time be at liberty in its absolute discretion to suspend temporarily and or terminate this agreement and all of the privilege hereby granted upon the expiration of 1 month notice in writing, its intention to do so being left at sent by registered post to the registered office addressee of the licensee, and notwithstanding that the licensee may have executed any work of a permanent or temporary character and incurred expenses in the execution thereof, the licensee shall not be entitled to any damages or compensation by reason of such termination or suspense. So from this Malad agreement, it is crystal clear. The notice they have issued without mentioning the name and by putting a simple on the board of the shop room is totally partly illegal, partly Malad in violation of the provisions of law, as well as principle of natural justice.
Should be a 30 days notice.
And second aspect of the matter is, my lord, I have placed the place of regulation. I have shown one for your lordship. If I say, my lord, there is so many orders, it will take time.
Yes.
For the change of ownership circular, and I have so many is there.
You've placed that, yes.
My lord. Then, my lord, the intention. What is their intention? There is simply they have written that we have to show notice. My lord, kindly at page starts from, my lord. Then, my lord, kindly, I am troubling your lordship. That I will kindly take up my lord, exception. My exception to the report at page 17.
Yes.
My lord, this policy was adopted in the year 1987, 1998. Page 17, relevant question.
Yes.
My lord, typed copy at page 19. It would be better for you also kindly have a look to the typed copy. Page 19 is the typed copy. My lord, the policy regarding extension of plot of land, change of ownership, etc. In view of the circumstances explained in your letter referred to above, the matter has been examined on partial modification of board's letter number such and such dated 3/3/87. It has been decided that in cases where plot holders are running their businesses on behalf of the original licensee on power of attorney, the present plot holders may ask to apply afresh for allotment of the same in their name. The rate of license fee should be fixed at 20% of the market value of land as provided by the board's letter number dated such and such dated 29/8/1995, subject to realization of all outstanding dues with 7% interest before entering into phase agreement as a one-time exception with the condition that plot shops should not be transferred or sold on power of attorney to any more. Any violation in this regard would be viewed seriously. In cases where original licensees are medically unfit to perform their functions, the ownership right may be transferred to the legal heir, subject to the verification of the unfitness of the government hospital and furnishing of legal heir certificate. The transfer, however, will be as per the latest terms and conditions. Whenever the identity of the legal heir is not established, the license should be cancelled. Regarding extension of area of existing plots shall be at, it clarified that in view of the ban, old licensing of land for purchases not connected to railway working, no further extension can be allowed. So, my lord, in the year 1987, they have adapted, they have started implementing it for change of ownership, legal years, since 25/6/1998. So, for this submission of my learned friend that the petitioner is an unauthorized occupant, it's totally partially illegal. And while false affidavit have been affirmed before your lordship to suppress the truth before this honorable court. Well, this is my lord. I have placed it to 1998. Well, in my deed application, my lord, kindly have a look to page 154. 2014, my lord, the same, my lord, the circular was issued. Page 157. It starts from, my lord, 154. 150 is by RTI.
Yes.
And, my lord, 157 is the, my lord, their railway board's letter. My lord, the renewal of license. The original licensee was, my lord, the licensee general notice, my lord, the renewal of license. The original licensee was still in possession of their
2014.
my lord, 11/7/2014.
Where is your last receipt?
While I'm placing that. My lord, kindly have a look to page 34, SUVRA Maiti. (2022 23).
It is paid for 1 year.
We have to pay for one time. After March, after completion of the financial year of 2000 March, my lord, we have to pay. Then, my lord, 37. Another repetition is Krishna Gopal Das.
So 23-24 was not paid.
My lord?
23-24 was not paid.
No, that I cannot, because 22nd March the notice was issued. After 31st March, I have to pay. Before that, they have issued the notice. We went there, my lord, to pay our license fees. They said, no, we have already issued the notice, so we will not accept it. I have stated in my writ application also that particular fact. Then, my lord, page 42, my lord, will find.
Yes.
Page 43, my lord, will find. Page 44.
So that's all your submission?
Well, only one judgment I place. So far is the
Have placed a judgment?
so far is the social responsibility is concerned, and that was also, my lord, relied upon one judgment, Dollar Industries Limited versus Port Trust Calcutta, Estate Officer Port Trust Calcutta. Today, my lord, somehow I discussed that particular judge. My lord, relied upon that judgment and passed an order, considering the social aspect, and that matter was went up to the appeal. I have checked it. I mean, the appeal also dismissed. My lord, order was affirmed by the appellate court.
Do you want to produce those judgments?
I'll submit that judgment, my lord, but that judgment is today not with me. Only, my lord, I have misplaced it today, my lord.
So let us hear, Mr. Ghosh. Please submit the judgments on the next date.
My lord.
Yes.
My lord, for a moment, kindly come to the page 21, just of the exception to the report.
Oh, of the exception.
Just now, my learned friend showed.
Page 21?
Page 21.
Yes.
My lord, that notice was, that policy guideline issued on 25th of June 1998. At the top bottom, my lord, right hand side, page 21. And then, my lord, kindly come to the clause 3. Regarding extension of area of existing plot stall, it is clarified that in view of the ban of licensing of land for purpose not connected with the railway working,
You are reading
no
at,
further extension can be allowed. My lord, that's SUVRA Maiti, if affidavit, sorry, my lord, affidavit in, that is my opposition, my lord, sorry.
you're reading the opposition, not the exception.
Archana, lord. My lord, that is affidavit in opposition, my lord.
Oh. Your report in the form of affidavit, that's what.
This page regarding, my lord, the writ petition number 10285.
10285, yes. No, in your affidavit,
My lord, exception to the report filed by the
petitioner.
My lord, it was filed by
Yes, the exception.
My exception, my lord. They are relying upon my exception.
Page 21 is rationalization of guidelines.
my lord, that was the name policy regarding the extension of plot of land, change of ownership, etc., etc.
Rationalization of guidelines for commercial licensing. Page 21.
No. Eta ki sorry, eta. এটা কি আপনাদের এটাই তো দেখছি includes this final copy of the exception of report filed by the respondent.
হ্যাঁ এই তো ওটা আলাদা দেখছি তুমি ওটা 21 নম্বর ওটা তিনটা
Anyhow, my lord, that was served by the learned advocate of the petitioner, my
I
lord.
cannot find the page actually.
Kindly see the top, my lord.
Regarding exception-
That was, my lord, issued in the year of 1998, and my lord, the last paragraph.
Give me
I
a
have
minute,
placed
please.
it.
It should be here.
I have placed it. Vivrala.
Oh, this is page 17. 25,698, page 17.
Accepting, my lord,
Page 17.
if
এটা ফেরত দিয়ে দিন।
ওটা একটু দিয়ে দিন। If, my lord, that is not related to the railway work, in that case, my lord, no extension is permissible, and railway is stop that extension, my lord. And my lord, that this
This is extension of area, not lease. 3 deals with
existing
extension of area of existing plot or
regarding
stall.
extension, my lord, extension means that an extension of the period, my lord.
Please read the sentence, sir.
My lord, subject policy regarding extension of plot of land, change of ownership, etc.
Etc.
Yes.
So extension of plot of land, not the agreement, not the lease.
Yes, my lord, that in the view of the circumstances explained in your letter dated such and such, the above matter has been examined in partial modification, letter number such and such. In the case where the plot holders are running their business on behalf of the original licensee or power of attorney, the present plot of holders may ask to apply afresh for allotment of the same in their name. The rate of license fee should be fixed in such and such. Then, my lord, 2, in case where the original licensee are medically unfit for perform their functioning,
Yeah, these
the
are
owner,
for change of ownership.
it is change of ownership as well as, my lord, that will not be extended if that
The plot,
their business is not related with the railway.
not that lease will not be extended. The
Anyhow,
area
my
will
lord,
not-
this is
the area of existing plot or stall will not be extended. It is very
regard,
clear
my
in
lord,
the
clause 3 regarding extension of area of existing plot
Yes,
stall.
yes.
It is clarified that in view of the
They are not
ban of
asking-
licensing of land, my lord,
Yes.
in view of ban of licensing of land for purpose not connected with the railway working, no further extension can be allowed.
What extension?
No further
of
extension.
extension of existing plot or stalls.
Yes, my lord.
Yeah.
Extension of
Not extension of agreement.
my lord, the last sentence, no further extension can be allowed.
Extension of what? The first line says so.
Extension of, my lord, the period of license.
No, and not at all. Carry on, sir. Yes.
Anyhow, my lord, and my lord, those circulars, whatever may be the issued in the year of 1998, thereafter, my lord, in the 2005, new circular was issued, thereafter 2010, and at present, all are guided by the 2017 circular. And my lord, in the 2017 circular, there is no such provision of extension.
Where is the circular?
I'm coming, my lord. Our Honorable High Court Division Bench has already been clarified that. And my lord, only, my lord, if in case, my lord, the railway float e-tender, they can only participate. And nothing more, my lord, that can be neither, that can be transferred to their legal heirs or transferred to the any according to their wish, or that cannot be extended according to the 2017 policy. I'm coming on that division bench has been clarified.
So the policy. Please show me.
Yes, at present, my lord, all are guided by the 2017 policy.
Yes, but does that have retrospective
All that,
retrospective effect or prospective effect?
with the
Are the earlier cases also covered by the 2000?
yes, on the date, from the date of notification.
So that is prospective from the date
Yes.
of notification, not in the earlier cases.
Yes, my lord, in all existing cases also is applicable. 2017 policy is applicable. Yes, I'm coming on that. And before that, my lord, who can occupy the railway land? Who has authorized occupier, they can be occupied. And my lord, who are the unauthorized occupier? Who has no license or having no authority, they cannot My lord, they may have a license long back ago, which was not extended thereafter. And my lord, on last day, I have also submitted that there may be an agreement, but that was expired long back ago. And from the, my lord, the allotment letter also says, my lord, that is for only for 3 years. And my lord, most of them, they have failed to produce any agreement also, my lord, 1 or 2%. Even, my lord, for the sake of argument, we are holding that there was an agreement. But even then, my lord, that was expired long back ago. And my lord, the same was not, my lord, they extended by executing a fresh agreement. My lord, thereafter, my lord, they are paying, my lord, the only occupation charge. And my lord, the occupation charge and the license fees are quite different. Occupation charge is what for? My lord, they are occupying the railway plot, railway land. For this reason, my lord, they are paying that. That nothing indicating, my lord, for this reason, they are the authorized occupier. Authorized occupier and unauthorized occupier, my lord, both are have to pay the license occupation charges. They are the unauthorized occupier. For this reason, they are occupying the land. For this reason, my lord, they are paying. My lord, that doesn't mean that that is a license fees. My lord, that page 34, my lord, for a moment, kindly come.
Yes.
That is their based evidence, my lord. That occupation charge, receipt or occupation charge. And my lord, kindly see for a moment, page 34, my lord.
Yes, 34.
Yes, my lord, all are same. For this reason, I am not.
Yes.
Yes, only one I am
All
showing.
receipts. Yes.
Yes, my lord, for a moment, 34, my lord,
34
of the writ petition. Last line, my lord.
Last line here.
Yes, my lord.
The receipt is given.
Yes. On understanding on the occupant will vacate the building at 30 days notice.
Where is this 30 days notice?
That notice is, my lord, in the,
Individual notice of 30 days.
yes, page 151.
How was this notice served? How was the notice served?
Notice was pasted in their shop room wall.
Is that not service?
Yes, my lord. Kindly see, my lord, what is the meaning of notice. I have, my lord, no Xerox copy. After reading, my lord, I shall. Notice. A person is said to have a notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or such which ought to have made, or gross negligence, he would have no it transfer of property such and such. Notice is not the same as knowledge. Notice is a word which involves that knowledge may be imparted by notice, but notice and knowledge are not the same thing. Although loosely one something talks, if then, my lord, the next paragraph, a person is said to have a notice of a fact either when he actually knows the fact, or when, but for the willful abstention from the inquiry or gross negligence. My lord, the question is, my lord, a person is said to have a notice of a fact either when he actually knows the fact. So, my lord, in my case, he knows the fact. What is the purpose of notice? And it was pasted, my lord, in their wall, admittedly. For this reason, my lord, they have challenged this. Otherwise, if no notice was there, my lord, there is no question of, my lord, getting Xerox of that notice or copy of that and to challenge before your lordship. So, my lord, the notice was there. Question is, my lord, whether it is required to serve in each and every individual to that. My lord, my humble and respectful submission is, it is in case of a, my lord, the public at large when it is involved, my lord, it is the development project of the railway and for, my lord, the advancement of the nation, my lord. That is Amrit Bharat station project, my lord. For this reason, my lord, the huge area of 990 station of All Indian Railway is required. And for this reason, my lord, the Kharagpur station area is also required, my lord. And my lord, the railway is the base judge to decide what will be constructed and where will be the construction and what will be the nature of the construction according to the policy of the railway, my lord. So, my lord, that land is required. And, my lord, the huge land is required. Almost, my lord, the all surrounding area of the Kharagpur station premises, which are, my lord, the railway land, those land are required, my lord. For this reason, my lord, it is not possible to serve, my lord, in the name each and every. As because, my lord, they are the unauthorized occupier. And, my lord, also, my lord, somebody is occupying the land, my lord. whose predecessor was the original licensee. Thereafter, no license, nothing. They are just, my lord, like the own property, they are inheriting. My lord, there is no such provision of inheritance. And my lord, I have on last occasion, I have my learned friend also shown that from the page 72, my lord, that is letter of allotment.
Allotment letters, yes.
Yes, my lord. Page 72, man, all are same, my lord.
Yes, yes.
My lord, kindly see first paragraph. It has been decided to allot the above measure and plot of temporary license agreement for August 1979. And thereafter, my lord, kindly come to the
individual allotment letters.
yes.
Allotment letters were issued individually
At that
but
time.
the authority could not issue individual notices.
Yes. As because, my lord, when, my lord, that allotment was issued in the year of 1979, and that was valid for 3 years. Kindly come to the next paragraph, next page 73.
Allotment letter was not wasted, isn't it? It was
Yes, for a period of maximum period of 3 years. Paragraph E, my lord. Next page, paragraph E. And my lord, if the railway reserved the right to terminate the license at a short notice without payment of any compensation for the structure built on the above plot.
dispute. No dispute. Yes.
Then, my lord, kindly come. What is at present? What is the status of the present writ petitioner? That I have explained at my paragraph 6 of my petition, my lord.
6
of my report.
Yes. Paragraph 6.
Paragraph 6, my lord. And in the 3 writ petition, in paragraph 6, I have to explain what is the present status of the writ petitioner. My lord, page 3, my lord, your lordship got it. I most respectfully state that the status of all petitioners in nutshell as obtained from the office record for the purpose of proper disposal and kind consideration of this honorable court. That total 16 numbers railway plots are involved in the instant writ petition, but the status of the each petitioner is not same. That 3 numbers of petitioner being petitioner number 2, 11 and 13 claimed as licensee for the railway plot numbers STN 20, STN 1009, STN 25 respectively are false and fabricated. The plot number STN 20 has been transferred to plot number STN 74. I have annexed that document, my lord. Long before, by letter number such and such, dated 3/2/1988. And the plot holder, plot number STN 74, is not the petitioner of the instant writ petition. No record is found for the railway plot number STN 1009 in question. And railway plot number STN 25 was terminated long before. Void notice number such and such dated 31st December 1997. So the petitioner number 2, 11 and 13 claim as licensee of plot number STN 20, STN 1009 and STN 25 respectively are purely false and fabricated, and they are entering upon the railway property without lawful authority and misuse such railway property and also refuses to leave, so that they are nothing but a trespasser, unauthorized occupier over the railway land in question. Well, those letter is annexed here. C. The remaining 13 numbers of railway plots are temporarily licensed long before in the year of 1979 for 3 years only, in which 9 numbers of plot holders being petitioner number 3, 4, 5, 7, 8, 10, 14, 15 and 16 or their predecessors neither signed any temporary license agreement with the railway nor renewed their license thereafter, but possessing of the concerned plot was already handed over to the other parties without any permission of the railway and by violation of the Railway Act. It was also specifically stated in this license agreement that the licensee has no authority or right to transfer the impugned plot of land to any other. My lord, from the In the allotment letter, it was also stated, my lord, page 72 and page 73, my lord. Then your lordship kindly come to the D. And 4 numbers of plot holders being plot number, petitioner number 1, 6, 9, and 12 had renewed their license in the year between 2011 to 2015 for 5 years only. But all the renewed license period have already been expired long before. That is prior to May 2020, and not renewed their license thereafter. All this information was noticed when survey made by the railway in the year of 2021. As because, my lord, prior to this Amrit Bharat station project, railway, my lord, one survey was done in all over India. My lord, what land is required, my lord, how much land is there. That as per various clauses of the usual temporary license agreement, the petitioner are also liable to vacate the occupied railway plot in question. The clauses number 15 of the usual license agreement clearly state as follows. Then, my lord, kindly come to the last paragraph. The respondent, my lord, then your lordship kindly come to that policy.
Where is the clause restricting transfer?
Yes, no transfer is.
Where is that recorded? Because you have a transfer
Yes,
policy.
and annexure R3, my lord.
R3.
Yes, I am coming, my lord, one by one. My lord, for this, kindly come to.
Read out that transfer was not permissible.
Yes, yes.
That's why I'm asking.
I have annexed. I have annexed.
Please tell me the relevant pages.
Kindly come to the page 11, my lord. That is, my lord, the scheme.
Yes.
Amrit Bharat Station Scheme of Indian Railway. My lord, question of development of the nation is involved. And for this reason, my lord, an unauthorized occupier without, they may be the license long back ago. But at present, they have no license. They have no agreement. And they have also, my lord, not failed to demonstrate before your lordship. Whatever may be their best evidence, that is the occupation fee receipt, that was also for 1 year ago. My lord, that was expired in the 2023 March for the financial year 2022 April to 2023 March. And admittedly, notice was issued thereafter. And
before that.
And my lord, in the last line of the notice, it was also stated that within the 30-day notice, my lord, they will vacate. In the last line of the notice. And my lord, kindly come, page, page, my lord, 42.
Of your opposition?
Page 33 of my opposition. I am showing from my opposition.
33.
Page 33. My lord, that scheme starts from page 11, that page 12. My lord, which station are involved? Page 33, my lord. Clause serial number 920. That Kharagpur station.
Yes.
And my lord, thereafter, that for the purpose of that project, my lord, time to time, railway issued, my lord, the further notification. That was one of that, my lord, the page 42, my lord. That is the morality of the scheme, board objectives. And my lord, the four is the scope. My lord, why the railway is taken? My lord, I am not, my lord, it is only sole intention of the government to develop the nation, my lord. Admittedly, my lord. And my lord, kindly come to the page 47.
Yes. The master plan.
That is, my lord, their general plan, how that will be chalked out, my lord. That program is also there, page 47.
This is not in dispute. The scheme
Yes.
is not denied. Only the eviction part.
R3. Yes, my lord. Kindly come to the page 56, my lord. Your lordship, just now, what is the clause 615?
56?
Yes, my lord.
Yes.
Page 56, type copy is there, my lord. And that relevant clause. My lord, the suspension and determination of the agreement by the president. My lord, that is clause 15, my lord.
Clause?
Page 63, type copy, my lord. And originally is page 62, my lord.
Yes.
My lord, the administration shall anytime, your lordship got it, bottom, my lord, suspension and
Yes.
determination of by president. The administration shall anytime and for the time to time be at liberty, it is absolute discretion to suspend temporarily and not terminate this agreement. And all of the privilege hereby granted up the expiration on one office address of the licensee, and notwithstanding that the licensee may have executed any work of a permanent or temporary character and incurred expenses in the execution hereof, the licensee shall not be entitled to any damages or compensation by reasons of such termination of suspension. Thereafter, my lord, the Hindi version is there. Your lordship was rightly pointed out that the notice should be served in the person in their individual name. My lord, if they are the licensee, but I have, my lord, demonstrated from my paragraph 6, they may be the licensee long back ago, but at present, not at present, more than 1-2 decades ago, my lord, they are not the licensee. Somebody is occupying on behalf of the original licensee, which was also, my lord, expired long back ago, just 3 years from 1979. And thereafter, my lord, they are paying the occupation charge. Occupation charge, my lord, that
Yes,
does not create any right that I am a rightful holder, man.
So there is no restriction to transfer in the agreement.
Yes.
Where is it?
They cannot be transferred,
Where
man.
is the clause? Because if the railway has a transfer
Yes,
policy.
that clause is also here. Yes, that clause is also here, man.
You've just read out the agreement. I do not find the clause. Because the railway has a transfer policy, and there are documents to show that railway has allowed transfer of ownership.
There is, my lord, at present, there is no such. Actually, my lord, that whichever the earlier policies prior to 2017, my lord, those policies are not applicable.
Where
And my
is
lord,
that stated now? That
yes.
previous policies are not applicable.
এটা একটু দিয়ে দেবেন। The appeal is, my lord, that is, the judgment was passed on 3/5/2017 by our division bench, by the Honorable Justice Nishita Matre, at that time the acting Chief Justice, and the Honorable Justice Topobroto Chakraborty. My lord, in MAT number such and such, I also, my lord, appeared in this matter, my lord. The appeal is directed against the learned single judge order dated such and such in writ petition by order dated 19th April 27. The learned single judge has not accepted the contention of the appellant that she is entitled to have renewal of her license for running a store on a railway platform. The learned single judge was of the opinion that the circular dated 15th March 2017, well, that is which is applicable at present, my lord, could not be held to be applicable to the appellant as she had failed to establish the fulfillment of the parameters stipulated in the said circular, the only basis of which the appellant claimed that she was entitled to renew of the license was that she had enjoyed the facility from 1995 and that she was not aware of the circular dated 15 March 2017. The requiring her to submit an affidavit, the learned single judge has disbelieved the contention of the appellant that she was a licensee as she was not able to place any documents on record to establish this fact except some documents indicating that she had deposited license fee up to, my lord, that was also, my lord, occupation charge of 31st December 2016. It has been sought to be argued by the learned counsel appearing for the appellant that in view of the judgment of the Supreme Court in Senior Divisional Commercial Manager such and such, reported in 2016 Supreme Court, page 668, the appellant was entitled to have a license renewed under the catering policy 2010. The submission is fallacious as a catering policy 2010 as given way to the catering policy 2017, which effect from 27 February 2017. Under this policy, no license is to be renewed as a stall would be licensed to vendors by e-tendering. Apart from this, by catering policy 2017 has not been challenged by the appellant in the petition or in the present appeal. We do not therefore see any reasons to interfere with the policy decisions of the railway. Hence, the appeal along with the count number such and such is dismissed.
This is with regard to renewal of license. They are not claiming renewal at all. They are challenging the notice on the ground that it was not in accordance.
Not only, my lord, renewal. My lord, when question of renewal arises, after
just for 5 minutes.
after my lord, when question of renewal is arises, after expiry of the for a particular period, my lord, in that case, period was expired when? After 1979, 3 years.
They are not claiming renewal at all.
Yes.
Not a case of renewal.
For this reason, my lord, they are the unauthorized occupier. There is no license at all. There is no license at all. And
You have submitted that.
And my lord, kindly see that is the Railway Act. My lord, according to the Railway Boards Act, my lord, the each and every policy guideline of the Railway Board has a statutory force. The only 2-3 sections, my lord.
These are not disputed at all.
Yes. And my lord,
Policy and all are not disputed.
yes, and my lord, for a moment, my lord, kindly consider that policy of the Railway Board, that is the Amrit Bharat Station project. That scheme was also introduced by the Railway Board on the sanction of the central government. So, my lord, that policy also have a statutory force and which is not under challenge. It is not challenged that the land is not required for that purpose of that.
There is no challenge at all.
For execution of the policy or for development of, when, my lord, the question of development of nation or the execution of a policy of the government is involved, my lord, that unauthorized occupier, my lord, cannot be obstructed, my lord.
Can be thrown out? Just thrown out?
Unauthorized, my lord, otherwise, my lord, they without, my lord, issuing notice, my lord, that they can be evicted, my lord. That was not done.
Where is that provision that they can be evicted even with
147(2), my lord. My lord, in that case, my lord, the Railway, my lord, they issued that notice. That provision is also there, my lord. That provision, my lord, but the Railway not applied that provision here. With the liberal view, my lord, they have issued that notice. And my lord, that I am also relying, my lord, the definition of unauthorized occupier also here, man. বইটা একটু দিন দিদি, নিচের পেজটাও আছে ফ্ল্যাট লাগানো। And my lord, I am quoting, my lord, from the Mitra's legal dictionary, my lord.
Yes.
The notice and, my lord, the unauthorized occupier. My lord, the next flap page, my lord, the.
Give me a copy, please.
Huh?
Give me a copy.
Yes. And, my lord, that unauthorized definition of unauthorized occupier also. So, my lord, the question of execution of a policy of the government for development of nation, my lord, they cannot be obstructed as an unauthorized occupier. They have failed to show any such documents. They have any authority to occupy the railway plot, my lord.
Have you seen this? Notice and knowledge are not the same.
Yes.
You are harping on knowledge.
Yes.
That they have knowledge.
They have knowledge.
But here it says notice is not the same as knowledge.
My lord, the next paragraph, left hand side, top, my lord.
And I'll deal with
Yes.
it.
Knowledge and notice, my lord, quite different. My lord, my submission is this. My lord, they have received the notice. They knows that that was issued for their purpose. For this reason, my lord, they have challenged. And it was, admittedly, it was pasted on the their sub room, my lord, on the door or any wall, my lord, admittedly.
That's all. Yes, anything in reply?
My lord, reply, my lord, today will not trouble your lordship too much, but so far my learned friend has, my lord, the first, my lord, and this judgment. This is not applicable in our case. This is considering the e-catering policy. We are not under the e-catering policy.
At present, my lord, all are guided by
No. E-catering.
I shall
my lord,
produce
those is good.
Not given the 2017.
yes, 2017 policy. I shall give the.
2014.
annexed. It is not annexed.
It is
Not annexed to your report.
no, my lord. It's because I am relying the thereafter, my lord. So many decision was held. Justice present earlier, my lord, Chief Justice being Justice Topolbotu
In fact,
Chakraborty
the policy
division
is
being.
not under challenge at all.
My lord, for this reason, my lord, I am only showing this decision
My
as
lord,
because
in connection with e-catering policy, we are not e-catering. We are, our plot was allotted by the railway board.
Anything else?
My lord,
Nothing. That's all.
my lord, just one, my learned friend has referred, my lord, in their report, paragraph 6, on note says the plot number 1009 is not in existence, we didn't allot it. My lord, kindly have a, kindly take up my read application.
Yes.
and my lord, my my learned junior is want to add, my lord, one point. Kindly allow me to say that.
बोलो अमृता बोल बे
Your Lordship, there was a judgment of WPA 28553 of 2024. My learned senior was only arguing as respondent in that. Subroto Ghosh versus Union of India. In that, Your Lordship, it was stated that principles of natural justice cannot, it is settled principle of law that principles of natural justice should not be mindlessly applied to strike down any administrative action when no fruitful purpose would be subserved by affording the so-called aggrieved person with a right of audience. And the writ was dismissed on that ground, Your Lordship. I'll
say that here also no fruitful purpose.
Your Lordship, same line of railway. 147 was.
We shall produce the judgment.
My problem is this, my lord, I am in the bar. Duty of an advocate to assist your lordship, not to mislead. I am 34 years in this institution. My lord, my learned friend is well aware that judgment is, my lord, already held by this court as a par inferium, Subroto Ghosh judgment. But they are referring to. Earlier day also I submitted that. Earlier that I submitted that.
Not paring.
Now, my lord, the officers of the railway, how they are acting in this matter.
Yes, this
My lord,
is the decision judgment that is related
my
to
lord, with responsibility, I am saying before your lord,
Judge,
when I have started, my lord, I submitted.
submit.
The officers of the railway, without going to the records, affirmed a false evidence before this honorable court. How irresponsible officers they are. Kindly see, they have on note says plot number 100 have no existence. Kindly have a look to my deed application, my allotment letter, page 66. WPA, our read petition. 185. 10285.
66.
66.
Yes.
This is the allotment letter. And this is the money receipt, but 65 is my money receipt. That just simply says, my lord, we are authorized document. We did not pay the money. We did not allot that particular plot to us.
Where is the plot number?
My lord, plot number is 1009. Plot number 65, my lord, at the top, my lord, will find right hand side. And this person, my lord, his father was died in the Bangladesh war. This particular plot is reserved for the, my lord, military personnel. Through Jila Sainik Board, the petitioner was allotted the particular plot. And on says, my lord,
that's all.
Just only one, my lord, I am submitting today, my lord, I am not troubling more today.
By today, it's over. See,
no, my lord, judgment is there. My lord, judgment is there, also there.
You
so,
give
yes,
the judgment by today?
Next day, time. Just only one.
No next date anymore. It's heard.
Well, only one day, my lord, for this. So,
no, my
only one.
My lord, kindly, otherwise,
so, social responsibility is a vital aspect.
My lord, only by a copy of the judgment, I shall produce one copy of the judgment and he will produce.
For orders, no submission to be made on Monday, only the judgment.
Only judgment.
That's all.
My lord, judgment is there.
My lord, kindly record that. Kindly, my lord, record that. Otherwise, my lord,
or instead of Monday, my lord,
Tuesday,
my lord, tomorrow, my lord, tomorrow also, my lord, we can question of produce the judgment.
Tomorrow, I would not prepare. Would not.
Third learned counsels for the parties.
Tuesday.
Arguments concluded. Let the matter appear under the heading for orders on Tuesday, 6th.
My lord.
On 6th February. Only the judgment.
And my lord, no argument will be advanced. My lord, kindly, my lord, It is,
Recorded arguments concluded.
yes. Your lordship recorded that gratefully.
And what about the other two matters?
Same order.
Covered by the same judgment?
Same.
They are other petitioners.
Petitioners are different.
My lord, extension can limit. I mean, I have filed an application for extension of interim order. Can number 6. Can number 6.
It was till today.
It was listed.
Uh,
I have served the notice upon the
till
land.
disposal. No, because
Till Monday.
till disposal, I'm on the verge of delivering a judgment.
On the delivery judgment. My lord, these are-
The paragraph, the interim order granted earlier is extended till disposal of.
My lord, instead of till disposal, my lord, any date, my lord.
Arguments are concluded. You have to wait
Arguments
for the
concluded,
judgment.
Argument conclude just a judgment.
Yes,
Oblige.
next matter.
Oblige.
Same order, 5, 6, 7.
Yes, my lord.
No. 5, 6, 7, same order.
And my lord, shall I take back the dictionary so that I can?
Yes. Please give me a copy of the relevant pages.
Yes.
I am for the petitioner, my lord.
Yes.
But petitioner are the land owner. Petitioners are the landowner, and their land has been acquired for purpose of widening the NH34, my lord. And notice was served.
National Highways.
And my lord, they given me the compensation money. I put my objection. That is page 29.
National Highways should be appearing. Oh, National Highways is not a party.
Not party. My lord, because competent authority is the my lord, here, my lord, competent authority, authority to take decision, my lord.
Page 29.
29, my lord, I made application, my lord.
Yes, thank you.
Widening of the national highway.
Fair
I mean-
compensation.
Oh, this is your application for enhancement.
Yes, my lord, enhancement. And my lord, to that effect, my lord, I annexed one document, my lord, page 32, my lord. That is the, my lord, General Manager Land Acquisition issued a notification. That is, my lord, relates to applicability of Act 2013. My lord, may I read this, my lord? My lord, subject Ministry decision regarding applicability of Section 24 of Rehabilitation and Act, that is called Act 13, my lord.
Section
Real
24
right
has
of-
been decided
right to
by the
fair-
Supreme Court. Section 24 has been decided by the Supreme Court, isn't it?
But
Applicability.
yes, my lord, that is why, my lord, this notice was issued, my lord, and here, my lord, paragraph 3, my lord, it is therefore seen from the legal opinion accepted by the ministry that wherever award of compensation under section 3G of NH Act 1956 was declared, the CALA on or before 31st December 2014, but compensation in respect of majority of land area notified in the relevant 3A notification was not deposited in the accounts of beneficiaries on or before 31st December 2014, then all beneficiaries shall be entitled to compensation in accordance with the provision of Right to Fair Compensation Act 2013. Well, my account, kindly come to page 30, my lord. I received this amount on 3rd December 2014, 15. So, my lord, the cut of date is
applicable in your case.
but yes, my lord. My humble submission, my lord, let the CALA be directed to take dispose my application in the light of this decision, my lord. Ministry's decision. That is
The
page 32.
Acquisition was under the National Highways Act.
Yes, my lord.
So you have 3G5.
Yes, my lord. The 3G5 is there, my lord.
Where is your
3G5
3G5 application?
But 3G5, my lord, there is say my lord, that one application. Well, kindly see.
So let this be treated as 3G5?
Lordship. If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on an application by either of the parties. So, my lord, I made application. Let the take decision.
Arbitrator is not the arbitrator. Who is?
Yes, my arbitrator is there. CLA is the arbitrator. As per the provision, my lord.
The respondent number?
Respondent number, my lord. I am just kindly respondent number, my lord. 4, my lord.
Additional receivers is not the
না
arbitrator.
জেনে শুনে।
Mr. Bandyopadhyay, who is the arbitrator?
My lord, he has received the amount
competent authority determine the amount. He has received the amount in the year 2015.
He's asking for enhancement.
There is no, my lord, there is a provision of arbitration. He has not made any application before the authority for enhancement. If he is not satisfied, my lord, your lordship
His
knows very well.
application can be treated as one under 3G5. Who is the
I
authority?
don't know, my lord, whether the arbitration has been held or not. If your lordship direct, my lord, then it will be referred to the arbitrator if it is not held. As yet.
It cannot be held because the petitioner has not been given any
He
notice.
is not aware about this. What is?
Who is the arbitrator, Mr. Bhatwada?
What are you telling?
But then, my lord, I take instruction, my lord, whether the arbitration has been held or not.
There is provision, my lord, section 3G5. I made an application.
Sent to
The
whom?
button,
Who is the arbitrator? Can you assist the court?
Problem to তোমাদের না জেনে কথা বলো।
Arbitrator is the competent authority, my lord.
Arbitrator competent authority হয়।
Determined by the arbitrator to be appointed central government. So what is CLA is the
Competent authority cannot be the arbitrator. Yes, can anyone say who is the arbitrator?
He has made a representative. My lord, your lordship kindly turn to page 30. 30 and
Then
31.
let me direct the ADMLR to refer it to the arbitrator.
If it is not as yet, my lord. If it is not held as yet.
I don't think it will be.
I do not. Then
It cannot be held because the petitioner will be aware.
he is not
Even
aware
if
of that.
it's
He is my lord, telling the competent authority is the arbitrator.
held without notice of the petitioner, then also it cannot be considered.
My lord.
Well, it is the duty of
Representation be considered, my lord.
Yes, yes. It is submitted on behalf of the petitioners that the petitioners received compensation in lieu of acquisition of their land, received compensation ওখানে date দিন on 3rd December 2015 in lieu of acquisition of their land. Stop. Learned counsel for the petitioner has taken this court to a notification issued by the General Manager within bracket land acquisition bracket closed, comma National Highways Authority of India on 3rd February 2016, which states that if award of compensation under section 3 capital G of the National Highways Act 1956 was declared by CALA on or before 31st December 2014, but compensation in respect of majority of the land area notified in the relevant 3 capital A notification was not deposited in the accounts of the beneficiaries on or before 31st December 2014, comma, then all the beneficiaries shall be entitled to compensation in accordance with the provisions of the right to fair compensation and transparency in land acquisition, settlement and resettlement and rehabilitation act, comma 2013. Learned counsel submits that the petitioners are entitled to compensation in terms of the 2013 Act in view of such notification. Stop. The petitioners submitted an application before the additional district magistrate before the concerned authority, on 19th December 2013 for enhancement of the compensation amount, which is yet to be considered. Stops. The petitioners pray for a direction upon the authority to consider the application at the earliest. Application. Paragraph upon consideration of the submission made on behalf of the parties, comma. No, it is submitted on behalf of the state respondents that the petitioners ought to have taken recourse to section 3G5 of the 1956 Act for enhancement of compensation. Paragraph Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since an application submitted by the petitioners is pending before the authority, the said application be treated as one under section 3G5 of the National Highways Act 1956. Stop. The concerned authority, being the fourth respondent herein, is directed to refer the application to the learned arbitrator
My lord, your lordship kindly direct the authority to consider the representation. If my lord, the arbitration is not held, if it is held, my lord, then it will be my lord. Your lord.
not be held without notice, Mr. Bandhavadya.
I don't know, my lord. Here, I have no
Not
instruction.
tenable.
I have no instruction my lord, to that effect, my lord. Then I have to take instruction.
No, I'll ask them to refer the application.
But if my lord, the arbitration already held, my
I'll
lord.
record that if not already held.
If it is not already.
Then, my lord,
It is not held,
then, my lord,
then it will be referred.
7 is the provision, my lord, the competent authority or the arbitrator while determining the amount under subsection 1 is the procedure.
Arbitration
So if the arbitration is there, then I have ought to have been give an
That is
intimation.
exactly what I'm saying. Since he
That's
has
it.
not received any notice, it cannot be said that arbitration has been held.
He's my
Well, it's a presumption. But it's a presumption. That cannot be, my lord. If it is not held, my lord.
He is standing for the respondent. He is taking the instruction.
কি বলে? For
If it is not held.
consideration
প্রসিডিং করলো তো
and
এর সালে হয়ে গেছে আর্বিট্রেশন হয়ে গেছে কিনা আমরা জানি না তো আমার তো ইনস্ট্রাকশন তোমার কথা তো হবে না তো যদি না করে থাকে ভুল করেছে তো নতুন করে হবে
disposal of the
হ্যাঁ।
same
আমি তো আর্বিট্রেটরকে দরখাস্ত করোনি আমি তো
in accordance with law
তোমরা আর্বিট্রেশনের
upon
দরখাস্তই করো
affording reasonable opportunity of hearing
আর্বিট্রেশনের দরখাস্ত
to all concerned, including the
ওটা আর্বিট্রেশন দরখাস্ত
petitioners, be afforded in accordance with law. Upon affording in accordance with law. Stop. The entire exercise should be completed within 3 months.
3 weeks.
3 months from the date of communication of this order. Disposed of that way.
মানে applicability of the opinion that is মানে annexed to D, my lord.
I have referred
Lots. Grateful one.
text.
ও বললেও বলে 15 সালে নিয়ে নিচ্ছে 13 সালে করে দিচ্ছে I beg to appear on behalf of Bakura municipality.
I beg to appear, my lord, on behalf of the state.
Petitioner,
Last occasion, my lord, lordship directed my landed friend to submit a report. Lordship kindly consider that.
Which I have. Yes. Now, my lord, kindly come to, my lord,
let the
page.
petitioner place his case first.
My lord.
Yes, Mr. Shamatri.
It has been demarcated. The landing question alleging encroachment of by the petitioner. It has been demarcated at distance of district magistrate, my lord. It has come to finding, my lord, that into a larger portion, it has come to, your lordship kindly come to report, my lord. 0.0096 acre of land. Initially, it was alleged that the report you will also kindly see. You'll also have has the report, my lord. Has the report, my lord.
Report, it was in the form of an affidavit.
No,
No.
File quantity.
These are the copies of the order sheets. This
Yes.
Yes.
No, the last but one paragraph, the last but one page, my lord. It will also kindly come, my lord.
The sketch map. Yes.
The addition distributed. So it is digital clear from the above facts that the concerned misproceeding was initiated, disposed of by the district magistrate Bankura.
Where are you reading?
To the order of the Honorable Court dated 12/2018, passed in WP number 500. In this proceeding, enough and
Where are you reading, Mr. Shamanto? I do not find it.
Kindly go to the last page. That there is a sketch map.
There's a sketch
Just
map.
before that, my lord, there is a communication dated 21st September 2016.
21st September, yes.
No, my lord, kindly
Prior to
go prior to that.
This is an order of this court.
This is an order passed by the additional district magistrate.
No, it's a coordinate bench order.
My lord is.
Oh, even
Yes,
before that.
yes.
Submission of brief history. This is.
Yes. Second page is referring that.
Yes.
It is crystal clear from the above facts that the concerned misproceeding was initiated and disposed of by the district magistrate Bankura in compliance with the order of the Honorable High Court dated 13/12/2018, passed in WP number 11,717/2016. During this proceeding, enough opportunities were given to the petitioner, and demarcation of the suit plot was also conducted to ascertain the present position and regard to the encroachment as found to be made by the petitioner of DSD. As it was found that there is still encroachment as acquired land, measuring 0.0096 acre of land by the petitioner, the district magistrate was left with no other option but to pass an order for demolition of part of the owned by the petitioner which has encroached the said in acquired land. Hence, this read to file is not maintainable in the abroad deserves to dismiss on the ground stated above. Initially it was alleged March portion. It was what kindly come.
বলতে চাইছেন দেখুন পুরোটা তো পড়তে হবে।
Has this been demolished already?
No, but I gave an undertaking in open court. That's how, my lord, I have stopped the authority to not to. There is no recording towards that.
No.
Right, sir?
Yes. No. Religious step has been taken, my lord.
Though petitioner moved this writ petition by saying that he was not given any notice, he was not present before the inquiry. When inquiry had taken place, he was not aware anything.
He was not present at the inquiry.
He was. There is every details. His sign was there.
Where is that?
Now, my lord, kindly come.
Page 21.
Kindly come to.
Page
My lord, after the order, my lord, let me kindly come to the order sheet first. My lord, this is 12th February 2019. My lord, starts with. My lord, its preamble is. My lord, there was a previous litigation, and in pursuant to that order, this proceedings is taking place. Now, my lord, kindly come to the third page. That is third order, 25th February 2019. My lord has got it. And then, my lord, kindly come to the next page. In that particular order, accordingly, the notices be issued to all the concerned parties. My lord has got it. Requesting them to remain present at the time of demarcation to be held on 6th March 2019 at 12 noon. Then BLLRO, then all the.
Order,
Sir.
Order sheet 5. Order sheet 5, you are showing. 5 kindly.
Notice duly served to the
Kindly see.
petitioner.
My lord. 5, your lordship, kindly see. That is the approach of my client. Kindly see, the case record is again put up before this today. Gone through the report regarding demarcation of the plot in question submitted by BLL Bankura, and it appears from the same that there is encroachment on the part of the petitioner over the plot in question, though the area of encroachment presently stands at 0.0096 acre instead of 0.0132 acre. Therefore, my conscience was right to some extent. They are taking much larger portion.
So have you removed this?
No. You are lost it.
Did you remove this?
I shall do it, man.
Within tomorrow?
Tomorrow? My lord, I cannot say, man, because my client is not present in court. That I cannot.
When can you remove this?
I shall.
Because the demarcation was held in your
their
presence.
it will be
Nothing further remains in the writ petition.
No, it is done in their presence. Because the area in question 96, they have to be.
Yes, yes, it has to be done in their presence.
Your lordship kindly give me.
Because if the authority removes, they'll charge you. They'll charge you for it.
I shall do it on my own. I shall give notice to the VLRO or the AGM. Your lordship kindly give some time so that I can.
That's good approach.
My lord, instead of giving him the task, my lord, kindly fix up a date where, my lord, my client would be present and the municipality would be present
No,
along with.
The petitioner will do it in presence of the respondents.
Kindly fix up a date. Otherwise, my lord, this has been happening since 2019.
Let there be a date. Tell me a date. When can you do it?
Yes.
Lordship kindly fix up a date.
Fixed up a date.
On that
Date and time, so that they can't take any further time.
And they have to be directed to be present, madam.
Yes, yes, of course, of course.
An area to be, the demolition area has to be demarcated by them.
The petitioner cannot.
We have already demarcated.
The this 0.96.
96.
96.
096.
0.0096
acres. You have demarcated this.
Yes. 0.0096.
Yes.
I cannot be, your lordship making, your making liable to my clients. What is my fault? I purchased the land, I approached for conversion, I approached for the sanction
Your
plan.
fault is you have
all along.
You have encroached.
After the acquisition, his vendor got the money, award was made, everything. He is claiming that I am not aware. How would you be aware?
You
are making mistake.
It appears from the.
I purchased maybe, but I approached the authority.
Sir,
You could have detected.
Vendor after receiving of the
vendor আপনাকে cheat
acquisition
করেছে, তার
money
জন্য
will not have
government
sold
কেন
out
ইয়ে
that.
করবে?
Maybe
আপনার vendor আপনাকে cheat করেছে, তার জন্য government কিভাবে দায়ী?
Detected at that point of time.
State respondents that
Making unnecessary or
upon demarcation of the plot in question, which was held in presence of the petitioner, it was found that the petitioner has encroached upon 0.0096 acres of land belonging to the state. Stop. The demarcation report and sketch map annexed thereto have not been disputed by the petitioner. Stop. The petitioner undertakes to remove such encroachment and restore possession of the said portion of the plot in favor of the state. Stop. Paragraph learned counsels for the respondents submit that such exercise be done in presence of the respondents. Paragraph fix a date. I'll record it. I'll record your consent. When can you do it? Next Sunday?
Yes. Yes. We have no problem. Sunday.
Government office আসবে?
Mr. Shamanto, next Sunday?
Next Sunday.
Sunday week.
What has to be given should be given. Don't wait.
No, I have not done that.
The more you keep it, the
Let
more.
me have some interaction with my client. Sunday
Court's
week.
order.
Sunday week, madam.
Court's order.
Yes,
I
Sunday
fix
week.
one date. The authorities will be present
I
on that
want
date.
to have some interaction to my client. With my
No, authority is taking the pain to
Sunday
be
week.
present on Sunday.
Sunday week at 10:30.
No. A particular date.
Sunday week, my lord.
Because then you have to come back and say the authorities were not present. It should
No,
be
no, I am
by
fix-
order of
I
the
am
court on
fixing-
a particular date.
I am saying, my lord, date is fixed. I am
My learned senior friend giving a date.
date, my lord. On the 11th February.
11th February, very well. Mr. Dhar, 11th February.
11th কি সানডে পড়ছে তো?
11th February. At 10 a.m.
And mention the time as well.
10 a.m.
10 a.m. it is not possible. 11 a.m.
11 a.m.
11 a.m.
Yes.
By consent of the parties.
Yes.
Paragraph by consent of the parties. Such demolition, such consent by consent of the parties fix 11th February 2024. No, by consent of the parties, such encroachment shall be removed by the petitioner in presence of the respondents on 11th February 2024 from 11 a.m. Paragraph, since nothing further remains to be adjudicated in the writ petition, the same is disposed of. Paragraph, there shall however be no arrears to costs as is specified.
Madam, there's a record the satisfactory regarding demolition. Your lordship can direct.
Yes.
Madam, after the demolition is carried out, they must, madam, record their, my lord, the satisfaction regarding demolition. Otherwise, nothing remains further.
I have recorded nothing remains.
Madam, your lordship kindly direct them to be present, but they have to be satisfied with regard to the demolition.
If they are not satisfied, they will come back. You have no headache. Isn't it? Next.
May I pray for one line? The entire removal of that encroachment process would be videographed. Kindly mention that so that no controversy remains.
At the cost of the state, that you take responsibility.
I'll take that responsibility. Kindly mention that.
Since nothing further remains, on prayer of the state respondents, liberty is granted to videograph the entire exercise at the cost of the state.
I'm deeply obliged.
Since nothing further. Next, mention matters.
Lordship, I am appealing for the petitioner led by Mr. Nilanjan Bhattacharya, who is appearing online.
I am opposing this application, my lord.
Item number 615.
Yes, I am led by Mr. Nilanjan Bhattacharya. He is appearing
My
online.
lord,
For the petition.
For the petition.
my lord, I am for the petitioner in this matter. No, my lord, I have been inducted as a lessee in respect of a port's land. My lord, after expiry of my lease, my lord, I repeatedly asked for renewal of my lease, but that was not considered. Now, my lord, all of a sudden, on January 2024, they asked me to vacate the premises by today at 11:30. I have a very innocuous prayer, my lord. Lordship knows very well, my lord, that in case of port land, if the want to, my lord, evict someone, that they have to take the recourse of eviction of unauthorized occupant act. So, my lord, my only innocuous prayer, my lord, that the petitioner shall not be evicted without a due process of law. Only prayer, my lord. If they, my lord, initiate a proceeding.
Where is the impute notice?
Page
My lord,
33.
page 33. My lord, I am ready to, my lord, contest before the estate officer, my lord. Only, my lord, let them, my lord, without due process of law, the petitioner shall not be evicted. Only prayer, my lord.
Yes.
I did not understand what prayer he made before your law.
The prayer.
Not to be evicted without due process of law.
Say that none, my lord, I am statutory authority. I will be in initiate proceeding under
But the council is relying on the 62 Act. 62 Act.
Yes, not
Eviction of
62 Act, it's 71 Act.
Oh, yes.
It's
Because the
71 Act. It's the
rent-
public premises unauthorized. We are going to issue thereafter the eviction notice, the under 4, and then we will initiate the proceeding.
My lord, the language is I have to hand over the possession today at 11:30. That is the apprehension, my lord. My lord, we are ready to contest before the estate
If
officer.
they don't do that, it doesn't mean we are going to evict them. We are a government authority. How can I just go using force and evict someone? It's not possible.
So I'll record your submission that you will take recourse to the 71 Act.
Don't submit record my submission.
Lordship.
The respondent authority submits that they will take appropriate recourse of law in case of eviction.
In case of default in handover, likha royeche default.
Lordship, and as a matter of fact, kindly takes page 34.
Yes.
Page 34, the impugn notice. Lordship will find, I don't know why he has made this. Lordship sees the last few lines. It is to be notified. Has your Lordship got that, man? Page 34. It is also notified that in case
Yes,
of
it is
default.
stated, sir. But
Yes,
the notice
it's
itself
written.
is very clear. The last 3 lines of the notice.
I don't know.
Yes.
My lord, the only thing, my lord, since they have specifically mentioned a date and time for
There
my
is
lord,
no
hand over the
necessity to
possession,
pass even
that
an
is the
order.
apprehension of the petitioner, my lord.
What is apprehension?
That is the only apprehension, my lord.
The notice itself says that they'll take recourse to law.
My lord, I'm also praying for that, my lord. I'm also praying for that.
Not intend to throw you out.
Yes.
My lord, I'm also praying for that, my lord.
Why the writ petition was not necessary at all. That's
Not
why
at all, my lord. And each court cannot, my lord, go on the basis of apprehension.
the notice issued by the estate manager within bracket I/C in charge. That is it. On behalf of Shama Prasad Mukherjee Port, comma, Kolkata Mukherjee MOOKERJEE, Port, comma, Kolkata. On what is the date of the notice? 15 January.
Yes, 15 January
On 15 January 2024 is assailed in the writ petition. The petitioner claims to be a lessee.
No, licensing.
A licensee in respect of the plot in question and was served with such notice by the authority. Paragraph learned counsel for the petitioner submits that the concerned authority may be directed not to evict the petitioner without taking recourse to law. Paragraph. It appears from the notice impugned no, the notice impugned indicates that in the case of default, in handing over vacant possession of the property by the petitioner, comma, the authority shall be at liberty to take recourse to law, comma, civil or criminal or both, as may be advised, without prejudice to any other rights, which may be available under law, and the petitioner shall be held liable for all costs and consequences arising therefrom. Stop. In other words, the notice very clearly states that the authority shall take recourse to law in evicting the petitioner from the plot in question in the event the petitioner does not vacate the same upon service of the notice. Paragraph. In view of such intention, of the authority as recorded in the notice itself, comma, nothing further remains to be adjudicated in the writ petition and the same is accordingly disposed of.
Much
It will, however, be no order as to costs as in certified website. Next.
Grateful, man. My lord, it is my lord, disposed of, my lord.
Disposed of, yes. Yes, anyone appearing? Mention.
Mention matter, nobody is.
ভোট দিচ্ছে ভোট দিলেও তো ম্যানসেট ম্যাটার দ্বারা কষ্ট করে ম্যানসেট
Everyone is busy for the elections. Must no. Shall I dismiss it?
No, the advocate on record.
So this says no to everything.
The lordship can place the matter in the next month.
None appears for the petitioner, no accommodation is sought. Let the matter appear under the heading motion in the monthly list of February 2024.
Sir, Amas.
May it please your lordship, my lord. I appear for the petition. Well, there are two matters, 617 and 18. My lord, they are between the same parties interstate. The facts are very similar.
Only
it's
the
just that,
plots are different.
it's just that it diverges at one point.
One by one.
My lord. My lord, it's easier, my lord, if your lordship takes up the next matter because the annexures are repeated. In the next matter, it's more comprehensive.
The second matter.
Item number 6, WPA 612 of 2014. My lord.
I take up 612.
612.
That's the first one. Yes.
I'm so sorry.
617.
612, yes.
My lord. But my affidavit of service, I'll just hand up.
The respondents are present.
Right. I'll just 612. Ha.
17 টাই আছে প্রথম যেটা বলছে 612.
Well, the facts are a little eccentric than the usual sand mining block. I want to surrender my possession. My lord, what had happened? Sometimes in 2017, my lord, an NIT was floated with respect to, my lord, grant of sand mining lease. My lord, the usual processes were taken care of. And of course, as contemplated in the auction rules and the concession rules, I'll take your lordship through that. Well, there is no possibility of physical inspection of the plot. Now, my lord, the deed was executed pursuant to, my lord, grant of environmental clearance. Whereupon, my lord, I entered the plot of land and I discovered there is no excavable sand in the plot itself. So, my lord, forthwith, my lord, I issue a letter, my lord, requesting them to, my lord, refund because there is no sand there. That, of course, has been kept pending for an inordinate period of time. And, my lord, the lease tenure in the meantime, there were a series of letters, I'll take your lordship through that, requesting them to, my lord, cause joint surveys and joint inspection. None of them have been taken care of. What had happened, my lord, sometimes in 2024, they have 2023, I'm so sorry, my lord, they have issued a letter, my lord, calling upon me to pay up the remaining monies which were due and payable under the lease deed. Now, my lord, that is challenged under 612 and 594, my lord, is my prayer for, my lord, refund of the monies because the lease could not have been granted. My lord, this is the sum and substance of my writ petition. My lord, kindly takes up, my lord, first page number 36 of the writ petition.
No, এটা নেই, joint survey, tender নেই।
The authority always banks upon a clause
My lord.
where it is stated that you have to take inspection of the property.
Yes,
prior to grant of-
the tender clause specify that prior to submission of the bid, applicant has to physically verify the subject plot and thereafter
An
the
inspection
applicant
has
will
to be-
submit the bid.
I'll answer your lordship.
The
I was
matter,
apprehensive,
this
my
is
lord.
the point taken by the,
Yes, I'm
that's why I'm pointing it out.
I'm grateful,
And in
my lord.
2019, it was communicated to the petitioner that there is no provision for refund of the amount. You may continue with the proceeding, but upon physical inspection, the bid was
No,
submitted.
there is no mineable reserve.
The petitioner, prior to submission of the bid, he inspected.
No, that's
And
not-
being satisfied, the bid was submitted.
I'll tell your lordship why.
Surprisingly, lordship, the tender is not annexed to the writ petition. If your lordship kindly permit us, we shall submit a report in the form of affidavit disclosing the particular clause contained in the tender notice. The tender is not a part of the writ petition.
I'm aware of the clause that my learned senior friend is referring to. It says that if a bidder is interested in causing inspection of the plot, he shall write to the BLRO and, my lord, upon permission being granted, can take physical inspection. Now, my lord, I am aware of that, and I have awarded in my petition that BLRO was sought, request was sought from the BLRO by approaching the hospital. But what is malafide on the apparent malafide on part of the state respondent? I'll tell your lordship. Well, June 15th to September, October 15th of every year, my lord, are declared to be monsoon seasons, because that is when the, my lord, the river, my lord, yes, and mining is stopped, all operations are stopped. Your lordship would see that the NIT was issued in July of 2017 that year, and I was, my lord, practically nagged to, my lord, complete all formalities within a period of, my lord, 60 days from date of that. And my lord, I had made over the 1/3 deposit which is required under the, my lord, the auction lease, and the LOI was issued on 6th of September. So my lord, this entire exercise your lordship would see was carried out during the monsoon season.
Yes.
Apparent malafide for this very reason. And my lord, the lease was executed on 2nd of April 2018, prior to which there is no provision contemplated in the auction rules to permit me to cause inspection over there. I can only take it prior to, my lord, participating in the NIT. And I cannot because of the monsoon season. And your lordships are aware, my lord, the BLROs and, my lord, the district delegates there, my lord, they're completely, my lord, they're non-cooperative. And what is even more surprising in the facts of this case, my lord, usually what happens is the course where the river runs, your lordship would find, my lord, plots embedded through the course of the river. There is no plot within a square kilometer of 4 kilometers from any radius of my plot. 4 kilometers from my plot, there are no sand mining blocks, which even made it more surprising. But that at the point of time, my lord, we had participated, taking note of whatever the disclosures were made under for me, which is, my lord, what I was indicating to your lordship in page number 36. Page number 36, your lordship would see that this is the Form A, the disclosures which has been made by the additional district magistrate and the district land and land reforms officer. It says that 60,000 square feet per acre per annum is excavable from there. And the ultimate depth of mining is about 3 meters from the riverbed. My lord, I can assure your lordship, my lord, I had recently, my lord, visited the site to, my lord, take in photographs of that particular plot of land. My lord, not even half of an inch of sand is there. And what is even more surprising, my lord, even though the lease deed was executed way back in 2018, I was never officially handed possession of the plot of land. What ordinarily happens, my lord, after the lease is executed, what happens is, my lord, the possession is handed over and the document is countersigned, which indicates that physical possession has been handed over.
That has not been
done. 5 years now. My lord, may I just, in that event, my lord, may I press forward with my application?
Yes.
May I just, my lord,
Yes,
place that,
continue.
please? My lord, page number 36.
From whatever submission you have made, a report is necessary from the
With your lordship. My lord, in that,
even if it is monsoon.
After the sand mining is prohibited, but inspection is not. No provision for
in the middle of the river. In the middle of the river. That is what my learned senior friend is suggesting. I cannot, my lord, that is when the river flows downstream.
You will have to participate in the field.
My lord, in that scenario, my lord, in
that part is also, if that part is also ignored, he says that possession was not handed
never
over.
handed over.
Actually, yes, I think you need to take instruction.
And my lord, your lordship would see.
If you have not handed over official possession, you cannot expect mining. Yes, Mr. Shah?
As soon as the lease is executed, it implies that the possession has been given.
No, no. My lord, that is absolutely Dios.
You always issue a possession certificate.
Absolutely.
In some cases, but not all the cases.
I think in all the cases,
Well,
I have come across possession certificate.
Yes, it is ordinarily issued.
LOI is there.
No, LOI does not, my lord. LOI is,
Certificate possession.
it says you have to get the deed executed.
Yes.
In that way, LOI does have to submit one part of the deed.
And I have.
No, one third.
If my lord, the LOI is never issued unless my lord I submit the 1/3, and it's there in the LOI. I'll take your lordship.
There's no dispute.
Kindly, my lord, comes to page 31. It says I have deposited. It's indicated there.
One third deposit. That is
1/3 EMD performance security.
Page?
137.
Yes, 137.
Notice of clearing. Forum play. You were the item picture in your software number second order 2070. You have so far deposited to the surrender. Do not be our surrender. You have not deposited to the surrender. The remaining amount of money as prior to expiry of the that is
Have you appeared?
I have. And I've placed the very same case. Which I am also hearing and notice because it was adjourned, my lord, on that particular day.
What's the outcome of the release?
You made a prayer for alternative plot?
No, for refund, my lord. Because I know alternative plot is not allowed, my lord. It's not permissible. They would be completely uncooperative. But if they want alternative plot, I am more than willing to take alternative plot. If they want me to give me refund, I'm happy with that. Whatever they say.
Please
but there's something has to be.
Not possible that was communicated to the petitioner in 2000.
It wasn't, my lord. It wasn't. I'll take your lordship. I'll take your lordship
Just
to
keep
that.
this somewhere. That refund is not
It was
possible.
communicated that no refund is permissible in terms of this.
What about allotting an alternative plot?
That was not his prayer.
Oh, of course it was. My lord, it's there. I say either give me refund or give me alternative plot.
It's your request
I'll
for
be
that.
more than happy, my lord.
Now, the thing is, in terms of person has to get a block through auction. So, see, this alternative plot without auction, it cannot be possible.
But where is the fault of the petitioner?
Fault of the petitioner, also the thing is, the tender was invited subsequent to issuance of the land availability and the mineable reserve availability in the particular block. That report is prepared by the mining officer. And the report which my last shows at page 36, it was prepared in prior to the auction was invited. Auction was invited in 2017.
Yes.
So at that point of time, there was mineable reserve, and so far the tender clause specified that the bidder they have to inspect the sand block and be satisfied thereafter. So the petitioner, as on now, he is saying that because of the monsoon season, he did not. That is not at all the.
So even if it is held that the petitioner was at fault in not inspecting, what about the possession? And after that, the petitioner has made several communications saying that there was no mineable reserve. So without addressing that, you cannot demand the remaining amount. Will you come back with a report? Please consider, I mean, not just a simple report for the sake of it.
My lord, may I just indicate one aspect because my learned senior friend has brought forth, my lord, the forms and the disclosures which has been. I went through the auction rules, my lord, and I also, my lord, on ground reality, what is the situation that happens prior to preparation of these rules? I have sought for instruction. What happens is, my lord, the auction rules provide for GPS tracking. Basically, what they do is the DM office as well as the consultant's office. The plot in question, my lord, is viewed using Google Maps. The holistic, my lord, from a satellite point of view, my lord, it is practically impossible to assess. It cannot. And this is a practice which has been going on since 2016.
That's the reason inspection is allowed.
It is, but in my case, it wasn't. My lord, I had approached the BLRO's office. And the time period was so stagnant. It was within a 15 days. You want to take the documents. If you want to, you are more than welcome to do it. Otherwise, you don't participate in the auction. Because even in the auction rules, it says, whatever disclosures have been made by the district authority, you study that and participate. I can take your lordship to the auction rules. It says that. It is only in the NIT that a further leverage is granted to the bidder that if you wish to go, you can do that. But in the middle of monsoon, my lord, this is not I have pleaded in my petition that I approached them. But this is not something which was afforded to me. And the malafide.
Those documents annexed to your petition?
My lord, that is a document, my lord, that I could not find. But I've pleaded that, my lord, in my petition and affirmed on oath. But the malafide, my lord, would also be evinced from the fact that 5 years have passed and I was not even given possession. So your lordship would see, my lord, we are ad idem on the fact that there is actually no sand. Your lordship would see the photographs, my lord, I have annexed on page number.
The mineable reserve that is there in the rule itself, chapter 3.
My lord,
rule 4 of
he's
2016.
reading out the concession rules. My lord, the concession rules come after the lease is executed. It is the auction rules which govern. Yes.
2000 rule is 2016.
The auction.
Lease was executed in 2008.
My lord, the auction rules govern the field prior to execution of the lease, and the concession rules is something which is brought forth after the execution of the lease.
Both are of 2016.
Both are of 2060. But my lord, the auction rules deals with a situation which is prior to the execution of the lease.
Prerequisites. Yes.
So if you lordship
You are on
rules 4
of the concession rules.
Concession rules. General condition for grant of prospecting license, mining lease and mining license and lease. Lordship, kindly come to 2A. The state government shall grant mining lease if the area applied for has been prospected earlier as per report of the Directorate of Mines and Minerals, West Bengal, and or Indian Bureau of Mines and or Geological Survey of India, or the existence of mineral contents there has been established otherwise than by the means of prospecting of such area. So unless there is a mineable reserve, the area cannot be put into auction for grant of mining.
No.
Does that happen every time?
There is a provision in the tender clause that the bidder has to inspect the particular sand block prior to participation.
You are more aware than me that this is not adhered to every time.
So the thing is, to some cases, it is my fault. I am sharing my personal experience. To some extent, it has shown that after grant of mining lease, the particular lessee, they extracted the mine within a particular time and thereafter came forward. Most of the cases it happens, they said that there is no mineable reserve. After excavating the sand.
Challans. Well, the challans would bear relevance. Not a single challan issued in my name. Because I was never given possession.
How is it possible?
Everything is possible.
That's
If he says illegal mining, my lord, he has a right to, my lord.
Exactly what I say that yes, there are several provisions in the book, but it doesn't always happen according to the book. Please come back with the report.
In the meantime,
Possession.
my lord, if he gives me an alternative plot of land, my lord, of course, I'd be more than happy.
Please consider this. He has not been able to start the mining at all. He has deposited 1/3. He'll deposit the remaining amount.
Absolutely.
If you can grant him an alternative plot. I mean, I am not calling for a technical report or just a report for the sake of it. Please consider these issues and come back.
Deal with the allegation.
Please consider these issues and come back.
My lord, in the meantime.
And not in an adversarial method. Let us come to some. There should be some solution to it, yes?
In the meantime, my lord, there is a proceeding that is sought to be drawn up against me.
Not drawn up as yet.
My lord, a notice has been issued, my lord, and
Service.
yes, I have, my lord, because I've
There
been.
is the impugned. There is the.
My lord, if he says there is no exigency, I'd be more than happy. Kindly record his submission that there is no.
There is the impugned.
My lord, 9th of January, my lord, page 137. Notice for hearing, my lord, I had participated. My lord, I have been informed orally. I've been informed orally, which is also my pleading, my lord, that some order is sought to be passed and a proceeding under the Bengal Public Demands Recovery Act is sought to be instituted against me. Which is why, my lord, the contingency has arisen. I don't have a copy of that order. My lord, he can do that anyway.
No, there is no question of staying this because this has already happened.
No, I don't want a stay of this, my lord. I am seeking for a stay of any adversarial steps. With regards to a possession, I have no car. But with regards to demand of money, my lord, that your lordship would kindly protect me.
They have not initiated anything as of now. You have not received any notice.
I have not.
In the meantime, if you receive, come back with a supplementary affidavit.
I'll do that.
Right?
I'll do that. I'll do that.
612. It is item number 617. 617 is এইটা 612 list. আমার হাতে যেটা আছে
সিরিয়াল নাম্বার 617 হচ্ছে WTA 612
যেটা আমার হাতে আছে ঠিকই বলছি 617 এ করে সেম অর্ডার হবে দুটোতেই সেম অর্ডার ইন বোথ দ্য ম্যাটার
No, my lord, it's a little different. No, stand blocks are the same.
let me just deal
Yes,
with this
yes, my lord, please kindly.
let me deal with this matter 617 এ করুন এটা order heard learned counsel affidavit of service heard learned counsels for the parties paragraph learned counsel for the Both of you want to come back with separate reports?
My report will not conducted.
Only state. Learned counsel for the state respondent seeks to use a report in the form of affidavit in this matter. Learned counsel is requested to take necessary instructions as to whether possession of the plot in question was made over to the petitioner, and if so, the date of the same, and also, whether an alternative plot can be made available to the petitioner for mining, since the petitioner was not able to commence mining operation despite depositing 1/3 of the bid amount. Paragraph, let the matter appear under the same heading. These two issues are primarily required to be
Yes,
seen.
my lord, of course.
When can you come back, Mr. 22nd February? Sufficient? 22nd February? Under the motion. Next matter. 618, please.
My lord, with respect to 618, my
Yes.
primary prayer is with regards to refund. Now, because my lord, their stand is that they treat the lease to be finished and done with. It is the performance security which has been deposited in their favor, which is, my lord, perhaps might be invoked in the meantime, which is why my lord, but they are correlated.
Several representations.
Several representations, but my lord, they are correlated. Of course, my
There will be, Mr. There will be conflict of decision.
yes. Let it be treated, my lord, let it be tagged and
asked to be considered.
yes.
It's related.
It is.
So let this also appear.
Yes.
Let this also appear on the same date.
Yes.
Because this consideration will go against him.
Direct that this matter will appear.
Yes.
And my lord, the invocation of the bank guarantee, because they have treated the lease to have been expired, which is why I'm seeking for an interim order that let them not, my lord, invoke my bank guarantee in the meantime. That is all that I think.
Since this matter pertains to a similar issue as in WPA 612 of 2024, let this matter appear under the heading motion on 22nd, I said, is it? 22nd February 2024, paragraph. The respondent authorities are restrained from invoking the bank guarantee submitted by the petitioner till the adjourned date.
I'm grateful.
See, if it is not, I believe it's a bank guarantee was submitted at the time of execution of the lease. If it is not renewed.
I think it is still the tenure of the lease. I believe it's been.
Tenure is over.
Well, I'll have to.
January 2000.
So if you have not renewed, then
I honestly don't have instructions on that.
Already expired in the meantime. There is
No. In the event that it is renewed, if your lordship adds that, I think it will take care of. Very well, my lord. I won't trouble your lordship.
It will be a redundant.
Yes.
Is it necessary? I think Mr. Bondapasa's report will cover everything.
Yes, same parties, my lord.
This is consequential.
Yes.
If the earlier one is decided in your favor,
Yes,
you get a relief here also.
Yes. I'm grateful, my lord. নেবে না সবাই আছে তো
Yes.
Lordship, I have.
You're for the petitioner?
Lordship, Mr.
Lordship, am I audible, Lordship?
Yes, you are.
Lordship,
Yes,
the case of Lordship, I am for the petitioner.
Yes, where is your affidavit of service? Oh, it's only the railways and the government also.
All of it, Lordship.
Service on the GP's office?
GP office.
GP's office has not been served.
No party.
No, Lordship. Lordship, as because of the I have gone through the writ petition, Lordship. The only concerned party is the railway authority, Lordship.
So well, expunge the name of the government. You've
uh,
implemented them, the land acquisition collector and the block land and land reforms officer.
Lordship, I have already made
Sir.
party. I have made party to all the concerned parties, Lordship. But
Mr. Dev, I request you to appear because they are served. Please serve a copy of the writ petition to Mr. Dev.
Lordship,
I'm
Lordship,
requesting him to appear in this
Lordship,
matter.
Lordship.
And the railways are not appearing. They are served.
The only concerned party is the railway, Lordship. The main fact of the case is that, Lordship, I have a plot which is adjacent to the Shagordigi railway station, Lordship. And for the extension of the railway yard, they removed one electric pole from their position to over the plot of the petitioner. The erstwhile owner of the plot made representation in the month of August. I purchased the said the petitioners purchased the said plot of land in the month of December. Thereafter, the petitioners made representations on several occasions, but the railway authority didn't concern the representation. Neither they initiate any acquisition process, nor they made any such transactions with the petitioners to remove the electricity pole. But the electricity pole is remain on my plot of land. For that reason, Lordship, I am no way use the plot, Lordship. The plot is not used by the petitioners at all. That is my grievance, Lordship.
Since the railway is not appearing today,
Lordship,
I think it will be a futile exercise to pass an order in their
Lordship,
absence.
Lordship, in
So
that case,
what-
Lordship, kindly direct them to file a report and adjourn it for 2 weeks, Lordship.
Direct whom?
The railway, I will communicate this
You'll
order.
communicate?
Lordship,
Let-
I will. I will.
That is the railways pole. It is electric pole.
Electricity pole of the railway authority.
Boundary pole. Boundary.
That's why the railways should be heard.
Boundary pole.
They are the answering affidavit of service. None appears for the respondents despite service. Mr. Dev, who is present in court and usually appears for the state owner at a regular court, please serve a copy to Mr. Dev. The grievance of paragraph, the grievance of the petitioners is that the railway authorities have shifted their electrical pole.
Boundary pole. Boundary.
Lordship, I'm tendering one. It is boundary pole, Lordship.
Yes?
Boundary pole, Lordship.
Boundary pole.
What does boundary pole mean?
Means the shift, the pole which is demarcated at the end of their plot, Lordship.
The not electrical pole, the boundary.
Boundary.
That the railway authorities have encroached upon a portion of the petitioner's land, which is adjoining railway land, by shifting their pole to the petitioner's land, apostrophe.
কাজ সব করা আছে পিটিশনে পড়া আছে
The paragraph, the railway authorities are directed to submit a report in the form of affidavit in this regard. Paragraph, since the railway is not represented, the petitioners are directed to serve copy of this order to the railways, to the railway authorities at the earliest. Paragraph, let the matter appear under the same heading under the heading motion on 23rd February.
Grateful, Lordship. Grateful.
My lord, they mentioned the matter in the morning. My lord, makes it, my lord, if it's otherwise not inconvenient for the court, my lord, 22nd, my lord, if it can be, my lord. Witnesses, my lord, available on that day, we have, my lord.
22nd.
Yes, it's a Thursday, my lord.
So on prayer of the respondent.
Respondent.
Election petition act order করে দিন. On prayer of the respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd February 2024.
Grateful, my lord.
All the days results.
I made my submission on the last occasion. An application where they are being for the appointment of arbitrator, because I can't remember. And I am the requisition body. So I was the requisition body. And my landlord by opposing my addition. In submitting that, I have no role to play in the matter of appointment of arbitrator. Because he is asking for the appointment of arbitrator under section 11 of the Temporary Provisions Act 1947. Even if I accept his contention, it is also cited one judgment. But my endeavor for addition of parties that here in this particular case, section 11 has no manner of application at all. The application, because it is a case for execution of rent approachment charges, not for a fixation of the initial fixation of the rent compensation. Therefore, once the rent compensation was initially fixed by appointment of the arbitrator once the arbitrator was appointed and was fixed the amount, thereafter subsequent operation, whenever it is needed to be enhanced, either increase or decrease, then the role of the first dairy collector comes in under different provision. Therefore, in that case, modification party that he cannot take that prayer and it has to be considered whether I should be added as a party, because once the order is passed, considering his condition that the arbitrator is appointed, then I will be in difficulty. That is my point.
If the arbitrator is appointed, why will you be in difficulty? If the amount is enhanced, you will be in difficulty.
No, not question of amount. Because once the arbitrator is appointed, you can automatically calculate the amount. But here in this case, the LA collector computed the amount subsequently. Revise the amount. Revise the amount and the amount of pay. Here in this case, the amount was revised. The minor is recorded. Therefore, it's a question of my appointment. Once the appointment is made, naturally, my lord, he is to consider the again afresh the.
You are appealing for the respondents? Yes.
Are seeking an appointment under section 11 of the relevant where under that if there is appointment to decide the action. But in this case, but as my not happening more because in 2007 was already an advocate appointed for adjudicator under this relevant section. What happens is the arbitrator adjudicator compensate 1989. Thereafter, they filed the distribution. Possession has been handed over much later, in the year in 2020. They filed the distribution that GMP is compensated for this period also. When justice standard, in 2008, till the date of handing over, you decide the compensation. After that, some transfer in March 2009, show date. Then, in the meantime, in 19 file a content saying that your justice standards order admit content has been in the proceedings the entire money has been paid to. Whatever was decided by the thereafter hearing.
Possession has been delivered.
Yes, possession also has been delivered. And then quotation 30 January 2023. So, he quoted arbitrated that January 2020, whatever was due or payable, upon giving pursuant to the order of Justice General has to pay. If Millard and arbitration records was to be appointed, could have been appointed in 18, but Justice General did it because the relevant section was not available.
Was there a prayer before the coordinate bench?
That retribution was there. The procedure would be that till 89 arbitration is appointed, he is not satisfied. Now he says fresh.
No, for the remaining period.
For the remaining period, the Justice General did not. He will say that the state will give them a hearing and decide on the compensation. So Millard, a different avenue has been Millard adopted. And thereafter we accepted that avenue. Then the content was filed, saying that the money has not been paid. So after that we paid. Signature Millard of the now in content, this after receiving that, they say that this is not fair or justice. This is what Justice General orders say, and Justice General will be not you avail whatever is available to you in accordance with law to decide whether to stay. From my humble submission, what we are seeking here, an arbitrator cannot go back and decide what is fair and
So what, according to you, is the proper recourse?
in this, whereas section.
Because I believe the petitioner is claiming enhancement. Primarily, he is claiming enhancement of the compensation granted.
Even this is not fair and equitable or not. Finally, now I'll show.
So who is the authority to decide? If it is not the arbitrator, who, according to you?
It is not the arbitrator.
Prior to that, do you see? Are you seriously objecting to the KMC being added?
Yes.
Because ultimately, if the amount is enhanced, it's the KMC who has to pay.
May I say this, Milord? On the last occasion, Milord, I had relied upon two judgments, one of the Supreme Court and one of this court. Milord, if Milord kindly takes the judgment of the Supreme Court for once, Milord, 2010, Volume 14, SCC 285.
Judgment গুলো কোথায়? কৌশিক?
Copy আছে extra তো দিয়ে দে।
File আছে কি? আরেকটা।
Yeah, I will also discuss.
Sure, definitely.
This is my point that revising is not available by the arbitrator.
Milord, first I'll be addressing my lord only
10, 14,
Volume 14, SCC 285.
Yes.
Milord, this is my initial endeavor, Milord. Milord, my initial endeavor would be to, Milord, restrain the addition of the KMC. To that, Milord, 2010, Volume 14, SCC, page 285, paragraph number 13 at page 291. At the commencement of proceedings before the arbitrator, the state government and the person entitled to receive compensation are required to state their respective opinions as to the fair amount of compensation, section 11(1)(d). Thereafter, the arbitrator has to determine the amount of compensation keeping in view the matters enumerated in clauses A, B, C of section 12. Once award is made and signed, the arbitrator has to inform the parties to reference by sending a notice in writing, as also to send copies of the award to the collector and the person or the person interested. What is most significant to note is that neither at the stage of fixing the amount of compensation by agreement, nor at the time of appointment of arbitrator, the state government is required to consult any person, including beneficiary of the requisition. The only person with whom the state government is required to negotiate the amount of compensation is the one whose premises are requisitioned. An application for reference of the case to the arbitrator can be made only by a person who was a party to the unsuccessful exercise undertaking for fixing the amount of compensation by agreement. If the state government nominates a person having expert knowledge as to the nature of requisition premises to assist the arbitrator, a corresponding right is available to the person whose premises are requisitioned to nominate the assessor. In terms of 11(1)(d), only state government and the person to be compensated have the right to state the respective opinions as to the fair amount of compensation. The amount to whom the requisition premises are transferred has no role in any of these matters. The use of expression the person to be compensated in clauses C and D of the section 11(1) clinches the issue. A person like the appellant certainly does not fall in the category of the person to be compensated. So, this is basically The Supreme Court dictum thereafter goes on to say, as a sequel to the above, it must be held that the person for whose benefit the premises are requisitioned or to whom the requisitioned premises are transferred does not have any locus to participate in the process of determination of compensation by agreement or in the matter of appointment of an arbitrator or reference of case. So, Mullah, the Supreme Court says the requisitioning authority, Mullah, has no business in the matter. Mullah, now this has been relied upon by our court. And in a matter involving the self-same parties, where Mr. Ghosh was appearing, kindly takes up 2012 SCC online, page 669.
We put a judgment for it. This is 2012 SCC.
Mullah, this 2012 SCC online calc 669.
Yes.
Mullah, sees the KMC versus Lolita Almol. Now, Lolita Almol happened to be the grandmother of the present petitioners, Mullah. Mullah, this was with respect to the earlier Mullah, this arbitration. There, Mullah, when we went to execute the arbitration award, a similar point was raised by KMC. Mullah, we took up this in appeal. Kindly see what the appellate court says. Kindly see what the appellate court says. Mullah, it relies upon this very judgment of the Honorable Supreme Court and then goes on to say, kindly sees, Mullah, the apex court observed as follows, as page 3, Mullah. I had placed this judgment, this portion of the judgment from the Honorable Judgment of the Supreme Court, Mullah.
Yes.
Now, Mullah, kindly sees the last two paragraphs of that. Relying on the decision as above, Mr. Ali contends that the corporation could not have any right to maintain the instant appeal, and the same is liable to be dismissed. Opposing the application, Mr. Alok for such and such, he relies upon a judgment of the Supreme of the court, and Mullah then just kindly turns over the next page, Mullah. I'll not bother you, Lordship, with much of the details, Mullah. Kindly takes over the next page. We have considered rivals' contentions. We have carefully perused the decision cited at the bar. It is true that this issue was not raised at the initial stage, when the division bench directed hearing of the appeal by condoning the delay. At the time, the division bench was not confronted with the decision or cited at the bar. In fact, the division bench decision in the case of West Bengal, such and such, this is the Supreme Court judgment I read to, was delivered by the apex court on such and such, where the division bench took up the hearing of the instant matter on such and such. In view of the change of law, the petitioner respondent is well within her right to maintain her application. Mullah, we took out an application challenging maintenance of the appeal because the amount that was assessed by the arbitrator, Mullah, was appealed against. On the issue raised by the petitioner, we are of the view that the apex court considered the judgment of such and such. While distinguishing decision, the apex court held that the West Bengal state, wherein the corporation being the beneficiary, was not entitled to maintain the appeal. Pertinent to note, the West Bengal state warehousing corporation was also a party to the proceeding before the High Court. Even then, the division bench held that it did not have any right to prefer the appeal, and as such, the decision was upheld at the apex court level. So, Mullah, viewed from any angle, Mullah, the corporation, Mullah, being the beneficiary, does not have any locus in the matter. And that's precisely, Mullah, we have not arrayed the corporation as a party. These are my submissions so far as the addition is concerned, Mullah.
Let me deal with this. Mr. Ghosh, I'm sorry. I don't think you are required to be added. The Supreme Court is very clear on this.
I'm submitting, this is the order arising out of the initial appointment of the arbitrator. Initial appointment of the arbitrator.
No. Even if we do not consider the division bench order, please come to the Supreme Court's judgment.
No, Supreme Court, the initial appointment, my point is there. Initial appointment, I accept that. Initial appointment, initial fixation. Appointment of the arbitrator for initial fixation of the amount.
It is not recorded that initial appointment. It is appointment at any stage.
That is my point. Here to consider, I don't know whether it has been decided as a successive occasion, whether in successive the appointment of the arbitrator could be made or not. Successive occasion. But today, you also can appreciate that.
This covers all arbitrations.
But today, all arbitration I understand. All arbitration I understand. But the question is a successive occasion. If the question of revision of the amount of rent compensation comes up, whether in that occasion the arbitrator to be appointed or not. Even in such case,
you are making your submission on the merits of the writ petition.
I'm not on merit. I'm just on merit, not on merit. Merit automatically comes up because merit automatically comes up indeed because of the reasons. I am appearing before Lordship to suggest that the appointment cannot be made. That is my point. That for that reason I want to be added as party. That appointment cannot be made.
You have no locus, Mr.
But
Ghosh.
if my point is there not regarding the appointment could be made. But if my point is there, appointment cannot be made. But there I could not be. But my submission is that appointment cannot be made.
You have
Therefore,
to first,
automatically then comes the consideration. Then you also could have rejected that my point is not there. But so far as the appointment is concerned, I can understand that the initial fixation by appointment of the arbitrator. I accept that judgment, what my lord is pointing out. But if successive appointment cannot be made, number one. Number two, it is a case of revision of the rent compensation. Therefore, if the revision comes up, either by the increase or decrease, different section comes up. Section 14, comes into operation. Therefore, my submission is that there is a section 11 have any application. That is the reason that I want to be added to the party. Then you should decide that you also could appoint the arbitrator under section 11, not required for section 400.
where is your prayer for addition of party?
My application,
It's GA1 of 2023.
GA1.
Where is the prayer?
And the prayer, we allow the instant application and to add the applicant claims as the party responding in the petition before passing any further order, in the matter.
G1 prayer to thank you. Prayer portion ta kothai?
Page number 7. 6 start with.
Page number 6.
6, when it starts from 6, 7.
To 1 of 23. He has given me the wrong application. Yes.
Application. Thereafter, I filed a supplementary VDP, there are certain documents giving their judgments. Supplementary.
Your ground is the KMC will be affected by any order.
I have supplementary filed an affidavit that is the affectation of supplementary affidavit. I have stated once the appointment has been made. Well, there was normally once initial application was like that. But subsequently, I gave the judgment initial appointment.
No, your ground for addition is you will be affected by the arbitration.
Affected means if the appointment is arbitrated, appointment cannot be made. Therefore, appointment is itself will affect me because my peer he cannot be appointed because of the legal provision, because of the facts on record. Here, I say the appointment of the arbitrator was made in the initial stage in the supplementary affidavit.
It is not your case that you want to participate in the arbitration. Sure. No. It is not your case that you want to participate
if
in
the appointment is not arbitrator is not appointed, therefore there is no, if the appointment is arbitrary appointment, therefore my contention may be correct, to be correct because of the Supreme Court judgment. But my contention that appointment of arbitrator cannot be made. And for that reason, your lordship automatically comes up the merit of the issue. Then your lordship said that my point does not stand. My point, the successive appointment cannot be made. But when the question of the increase or decrease comes, it's a revision. Revision for that revision, separate action, section 11 does not have any operation.
You have referred to a judgment in this regard. You have referred to a judgment in this regard.
Judgment, not judgment, I submit, the arbitrator was once appointed. Thereafter, there cannot be any occasion for appointment of the arbitrator. Because he could have objected to that when this honorable court in the earlier proceedings.
what my learned friend, well, also is hearing whether it is added or not. So let his application point on what he wants to say. I want to say the same thing. So, your lordship, if not decide or keep it pending this edition, because your lordship is also
Cannot be kept pending.
Yes,
It has to be decided first.
And one issue, my lord, if the state wants to take up the cudgels of the corporation, it might as well the corporation not get added. If the state wants to piggyback out the corporation's case.
It's the same issue which is being harped upon us.
Yes, my lord.
It's not that the state is taking up the cause of the corporation.
No, my
It's
lord,
not
kindly visualize, my lord.
No, question of causing, my lord.
No. The issue is very simple. The state wants the corporation's application to be kept pending. There's the issue, my lord.
that is an answer.
Yes.
All I want to say, Milord, is that if Milord, this additional party is Milord is subsidiary ancillary issue. Because what I am arguing is really the state convince your lordship on merit. So Milord, KMC will not perhaps stand in the way because I address your lordship Milord on merits. So Milord, this application will inherit some instructions. That is a solution. Otherwise, you cannot have
It's just like,
That
ma'am,
is the efficient of-
it's just like having a cause and a cause of action. I might have a cause, but that doesn't give me right to move the court if I don't have a cause of action.
The judgment that you have referred to deals with participation in the arbitration, right?
No, my lord, kindly takes up paragraph 16 for once. In the matter of appointment of an arbitrator. Paragraph 16, my lord, at page 291, next to placentum H. Even in the case of or in the matter of appointment of an arbitrator.
Mr. Ghosh, the Supreme Court is against you.
Your lordship, consider my point having regard to the judgment of the Honorable Supreme Court. But consider that judgment is there. I am not objecting to that judgment. But your lordship, consider, my lord, regarding the appointment of the arbitrator, initial fixation, and in the subsequent occasion, my lord, when that comes for the enhancement of the rent compensation or occupation charges, successive occasion, whether successive occasion, in each occasion, the appointment of the arbitrator could be made or not. Because today, your
The
lordship,
state has to respond to this, not the KMC.
if your lordship, my lord, that is the reasons, my lord, my object, my lord, too, because ultimately affectation of will be of my client. That is the reasons I am submitting, my lord, the appointment of the arbitrator.
The Supreme Court is against you, Mr. Ghosh. I'm sorry.
But if I suggest that whether the appointment could be made or not, but that could be the issue. That could be the issue to say that no, because you have no right. You should take care of my point. You should reject my point.
Yes, I'm
because this is my contention that successive appointment cannot be made. Successive occasion, my lord, the appointment cannot be made by the arbitrator. Number two, if it is a case of, my lord, the enhancement of the rent compensation because he is not satisfied with the amount which has been fixed, then what is the reasons for acceptance of the amount as made by the first LA collector?
This will be dealt with by the state, I believe.
No. I was a party to the proceeding before the Honorable Justice GHOSH Tandon.
Maybe.
I was a party to the proceeding.
Maybe.
Because here the court directed the first LA collector to decide the amount. LA collector, the order has been accepted by both the parties. The LA collector was appointed by the government as an officer of the court, as an officer of the state, and he fixed the amount. Then what is the role of the LA collector? Why he has came into function? So far as the rent compensation is concerned, LA collector did his job.
The Supreme Court is very clear on this that in the
Supreme
matter
Court,
of appointment of an
Supreme Court,
arbitrator, you cannot intervene.
if it is appointment of the arbitrator comes, if your lordship already considering that the appointment arbitrator to be appointment.
Stated here that subsequent appointments you have a right.
But that is the point to be considered by your lordship.
Cannot be. This application is rejected. The state is on your cause, sir. So you
No,
not be prejudiced.
that your lordship will consider because I have come with the I thought, my lord.
GA1 of 2023. The applicant heard learned counsels for the parties. Paragraph. The applicant seeks to be added as a party respondent to the writ petition.
Madam, may I take a loss?
Yes.
I take a loss candidacy.
On the ground
Clear is here.
that since there was an initial appointment of an arbitrator who decided the amount of compensation to be paid to the petitioner, comma, subsequent appointment of arbitrator is not tenable in law. Also, comma, in the event the amount of compensation is enhanced in arbitration, comma, the applicant who has to pay the enhanced amount is the requiring body, isn't it? The applicant is the requiring body. The applicant is the requiring body, the KMC.
Yes.
It was acquired and given to him.
Beneficiary.
Yes, the beneficiary. The applicant who is the beneficiary has to bear the said additional burden. Paragraph. Vehemently opposing the said application. You have no objection, you said.
I have no objection.
A paragraph, learned counsel for the learned counsel for the state respondents do not raise any objection to the application. Does not raise any objection to the application. Paragraph. Vehemently opposing the application, comma, learned counsel for the petitioners places reliance on the authority in West Bengal State Warehousing Corporation versus Indropuri Studio Private Limited and another, reported in 2010 within bracket 14 Supreme Court cases 285. Eta ache na? And submits that the beneficiary has no right whatsoever in the matter of appointment of an arbitrator, comma, reference of a case to the arbitrator, or participating in the arbitration proceedings. The relevant portion of the judgment is set out. Paragraphs 13, 14, 15, 16. 13 to 16 set out for them. In view of the above, comma, this court is inclined to hold that the applicant cannot be considered to be a necessary or proper party to the writ petition the application, comma, being devoid of merits is liable to be rejected. Paragraph GA such and such is rejected. There shall, however, be no order as to costs. Urgent certified website copy. কিন্তু দেখে নেবেন আমার অন্য। Yes, so we come to the merits of the writ petition. Yes.
Wait a minute.
Still continuing with this application. Petition ta hobe ebar. Yes.
This matter is a checkered history, Mulot. Under the Temporary Provisions Act, Mulot, 3 portions of the premises were requisitioned. Thereafter, Mulot, in 1989, a notification under Section 4 of the Land Acquisition Act, followed by a declaration under Section 6 it proceeded, Mulot. Thereafter, eventually, Mulot, the acquisition could not be completed. It lapsed. We moved this honorable court. Justice Tandon's order, Mulot, kindly sees the first relevant document, Mulot, is at page 23, Mulot. It's the order passed by Justice Tandon, Mulot, in my writ application. So 3 portions would be very material, Mulot. Kindly sees, Mulot, page 30 for once.
Yes.
running page 8, kindly sees the last 4 lines of the first paragraph. It is not in dispute that steps were taken for acquisition of the requisition premises, yet the acquisition proceeding has not reached finality because the collector did not publish the award and therefore would stand lapsed under section 11A. That's the first. Kindly then takes the trouble of coming to page 33.
Yes.
Running page 11. The paragraph starts with, it is thus manifestly. May I place it? It is thus manifestly clear that after the lapse of acquisition proceeding, as the award is not made within the time stipulated therein, the property cannot remain in requisition eternally. Since the extended period under proviso to section 10B of the Act has also expired in the midnight of 1992, the possession of the corporation is palpably wrong and or illegal and therefore is required to be given back to the petitioners. Kindly pause here for a moment. So, the possession of the corporation becomes illegal. So now thereafter, after 992, the corporation's possession in the property is illegal. Thereafter, kindly takes the next page. Kindly sees paragraph page 34. The paragraph, it is brought to the notice of the court, where the court was appraised of the earlier land litigation. It is brought to the notice of the court that the arbitrator was appointed by this court for ascertainment of the compensation required to be paid to the petitioners for requisition of such premises, and the said compensation was determined as far back as in 1989, and since thereafter no revision has been made as yet. My attention is drawn to section 11 of the Temporary Provisions Act, which provides mechanism and the mode of determining the compensation by agreement. And in the event such agreement is not reached, the state government is empowered to appoint a district judge or additional district judge and an arbitrator. Thereafter, this court therefore directs the state government to take steps relating to revision of compensation for the period for the midnight of 31st March 1992 till the property is acquired, or in the event no acquisition proceeding is initiated, the same is physically or actually delivered to the petitioners, exercise 8 weeks. They did not do. Contempt. During the contempt, they handed over possession, admitted possession. They also assessed the compensation that was liable to be paid to us till the date of handing possession, admitted possession. Now, this amount was paid to us. Now, we received that, we received that under protest without prejudice. Kindly sees Justice Tandon's order dropping the contempt at page 68. Relevant portion at page 69, the 4 lines from the first paragraph, last 4 lines. Whether the quantum of compensation is fair and justified cannot be gone into exercise of contempt jurisdiction the moment the court finds that the order has been complied with, open to the petitioners to take appropriate steps in permissible law. Now, thereafter, I write to them on 22nd of May 2023 at page 70.
Yes.
I lay out the entire facts of the case. Kindly sees page 71, It's the second paragraph, default on the part of the authorities.
Yes, yes.
Default on the part of the authorities concerned to comply with the directions contained in the said solemn order compel an application preferred before the Honorable High Court at Calcutta, same being registered as CC such and such. During pendency of the contempt application pursuant to orders assessed passed in connection therewith, possession of the aforementioned portions of the said premises were handed over to us on January 13, 2023. Steps were taken to assess the compensation payable in terms of the aforesaid solemn orders, and the compensation as assessed was handed over to us. We did letter dated such and such. Now, kindly sees thereafter, the receipt of the same was without prejudice to rights and contentions to seek recourse to appropriate measures with regard to the quantum assessed and the mode and manner of such assessment. So, we are reserved a right to say that we are not satisfied with the assessment made. So, now, what hinges on this is, till 1989, there had been an assessment. So, if, I was, or if I am, seeking any increment or any sort of change with regard to that assessment, it could have been within the ambit of increase or decrease. assessment, the earlier round of litigation, the assessment made was still 1989. And I'll show that order. It's also next, the award of the arbitrator. So, Mulad, now.
No, that's admitted.
Admitted. So now, Mulad, post 1989, an assessment has been made by the LSE. So, Mulad, this is a fresh assessment for the period subsequent to 89. Now, Mulad, they assess, they pay me. I accept this with a right and a caveat that I'm entitled to invoke provisions. In fact, even if I had not done so, it wouldn't have made any difference because that's the right I have. But now kindly see section 11 of the Temporary Provisions Act.
So do you have a spare copy of the
I
book?
believe I have one.
It আছে এটা Yes, you've handed over to me the earlier dates. It's there.
Yes, page 20, section 11. Mulad.
Yes.
Section 11, Mulad. Where any premises requisition out of the act, there shall be paid to all persons interested, compensation amount of which shall be determined in the manner in accordance with the principles hereafter set out. Amount of compensation can be fixed by agreement, shall be paid in accordance with such agreement. Where no such agreement can be reached, the state government shall appoint district judge or a district judge as arbitrator. This is the point, Mulad. This is the contention. Now, Mulad, I say the assessment that had initially reached finality was till 1989. Now that would emanate from the award passed by the arbitrator, which appears at page 74, and the relevant portion is at page 95. This is the award of the arbitrator, while assessing the compensation till the year 89. Kindly see page 95. See, the claimant is entitled to. So page 74, the award starts.
Yes, yes.
Page 95 is the relevant portion, see, the claimant is entitled to.
Yes, yes.
Such and such for requisition for the period 1380 to 89. Then such and such 79 requisition from 79 to 89. Such and such for
1789.
Yes. And thereafter, my lord sees why did the arbitrator, why couldn't the arbitrator rather proceed? She goes on to say, if I claim mean profits, there must be an adjudication that the existence of the party is illegal. Now that comes into existence only with the passing of the standards order, Mulad. So, Mulad, on the last occasion, Mulad, page 95, Mulad kindly goes through a little further, Mulad. The arbitrator restrains herself by saying that till now it is not proved that the.
Is that recorded?
Kindly sees, Mulad. Kindly sees, Mulad, the question is whether. Mulad, page 95.
Yes, yes.
Question is whether an award can be made in respect of such and such. The mean profits indicates wrongful possession of the premises of respondents. The test set by the definition in such and such is clearly the profits which the persons in wrongful occupation actually received or might with ordinary diligence be received from the property together with interest, and if not, what the original claimant loses by exclusion. So, Mother, till the time a person's presence or occupation is declared to be illegal, I could not have been entitled to any sort of compensation on account thereof. So that comes into effect only with the passing of the standards order. And therefore, I say section 11.2, 11.1b has a manner of application. Now, my learned friend will be probably harping on section 14 and 15. May I place it for your lordship? Let me play the devil's advocate for once. Section 14, Mulad. If section 14 and 14a could have any manner of application, see section 14, Mulad.
Yes, 1 minute. Yes.
When a dispute arises as to the person or persons to whom the amount of compensation or any part thereof is payable, or as to the apportionment of the same or any part thereof, the collector shall keep the amount in revenue deposit. Doesn't apply. Takes up 14a. The rent compensation of any premises liable to be increased or decreased. As I said, I am not with regard to the compensation assessed by the 89 award, so even 14a doesn't have any manner of application. So, my response submission for your lordship today is, an assessment has been made.
You are asking for increase of the compensation paid to you.
No, I am asking, my lord, in terms of 11(1)(b), that an agreement has not been entered into. So kindly appoint an arbitrator to assess the compensation, because I am not satisfied with the assessment made by the collector.
That's your submission.
That's the submission.
Yes.
This under what provision, Milord? He has not shown.
11. He says section 11.
11. Start with 11, then I'll show Milord. He says under 11, I am not happy with the assessment. Therefore, appoint. May I just, your lordship, have it. Procedure for fixing compensation. This is not revision. Fixing, kindly note. Where any premises are requisitioned under this act, there shall be paid to all persons compensation, the amount of which shall be determined in the manner and in accordance with the principle. Where the amount of compensation can be fixed by agreement, it shall be fixed. So, he is not on this, but what it contemplates, is that if I have taken his property and if we enter into an agreement and say that I am giving you X amount, he agrees, then no question of any arbitration. He is very wrong. No agreement can be reached. Then the government will appoint a district judge or an additional district judge as an arbitrator. So, if two parties cannot agree on what will be compensation, that case for fixing of a compensation and arbitrator will be appointed. It is not a case where you have agreed, you have taken the money, you are not happy with the money, and then now it's asking for release. And this is a specific statute.
What is the way out? Is there any other provision? Because arbitration is being sought for the remaining period. Till 89, there is no dispute. And this is not a subsequent arbitration. This is a fresh arbitration with regard to the remaining period.
That is perhaps not the case. Finally, the fact. And my learned friend understood that this is not a case. Finally, see, Milord, this award is from 2007. Though it allows till 1989, considers till the period at least till 2007. Till 2007, it is disallowed. It is not.
Where is that order?
It is evident from their letter. Finally, takes their letter at page 36. And that mean profit portion by learned. Finally, change this letter at page 36. What
30?
they understood.
32?
36.
Yes.
And even Justice Tandon understood that. But it was a division, I'll show that. But finally, take the letter 11th October 2018. 2 months after Justice Tandon. Last paragraph.
Yes.
No, Milord, I did the first paragraph. It's all ordered in Congress passed in the document. The acquisition proceeding part of the case is already acquired in no longer than having lapsed under section 11A of the Land Acquisition Act. So, Milord, the decision was that it had lapsed.
Yes.
And it was further held that it should consider that after the lapse of proceeding, the possession of the was certainly wrong and that proceeding was required. His lordship was pleased to get a order for a period of 6 months to enable the state to initiate fresh acquisition proceedings in respect of the state.
And that was not done.
Now, Milord, last paragraph. But this, Milord, is not perhaps correct. What this second statement. Kindly take page 32, Justice Tandon's order. Page 34. Just 2 pages before this.
Yes.
In the event the acquisition proceeding is not initiated as per law applicable on this date, immediately according to physical and therefore we are handling it. It is brought to the application was appointed by the court as well as compensation. Kindly below, that's the one that was required to be paid to the petitioners for execution of such payments. And the same compensation amount far back in year 1989, and since thereafter no revision has been made. My attention is drawn to the for both of determining compensation by agreement and in the event such. Next, this code therefore directs the state government, being aware of section to take steps relating to revision of the compensation. So, what the Justice Tandon directs is the revision of the compensation for the period from midnight 31st March 1990 till the property is acquired or in the event no acquisition proceeds. The same is physically and actually delivered to the patient. The entire exercise shall be undertaken of 6 weeks. So a specific direction was made for revision of the compensation not granted or disallowed by the arbitrator in 2003 for the period 1992 onwards. Still possession. My lord will note possession was given 13 January 2023. Now, below, and now it's not page 36 and 37. It is not what to be aware. We have exhausted all the provisions. Now we want to go back. That is perhaps that is not permissible.
I understand that the provision says the state government can appoint an arbitrator, not the court. Right? 11B says it's for the state government to appoint an arbitrator. If when no agreement has been agreed up, has been reached. Yes. So now, if an amount is paid and the petitioner is not happy with the amount, what is the recourse? What is the procedure?
Amount has been paid. He has accepted that itself is an
Is there any provision for enhancement of the amount in any of the other provisions? Because this provision is very clear. It's for the state government to appoint.
Yes.
The court cannot.
State has not appointed. Therefore, I am before your lordship. State hasn't appointed.
Justice Tandon's judgment.
Yes.
He has taken note of section 11.
Yes.
And has and has directed the state government.
Yes.
Yes.
To assess the compensation. That has been done.
In terms of section 11.
Yes.
That has been done. So now section 11 cannot be invoked further.
No, my lord. There's by
there is the other provision. I would like to madam, can you assist the court? What is the other provision?
My submission is that there is no other provision.
This cannot happen. That if they're not happy, they have no recourse to law.
If at all, they are not having the 11
ভোট ফুটে গেছে
now kindly take 14 and 14A. Deposit of compensation.
14 is not really applicable. Let us come to 14A.
Now they are not happy. Let them come and deposit the funding and go before the land.
14 is with regard to disputes, with regard to the person to whom it is payable and apportionment. So this is not, no. They are not happy with the compensation itself.
Very well. Then
No question. Let us come to 14A.
Increase in rent compensation. Rent compensation shall be liable to be where the rent compensation is share of the municipal.
Oh, this is contingent to this.
Increase where the landlord incurs any expense. The collector shall, on application made to him by the landlord to the prescribed manner, fix in respect of any premises the increase or decrease referred to in subsection 1. Provide 14A subsection 2 is there.
This is not.
Provided that the collector may notice in writing to the landlord who would to decrease rent compensation, no application from the landlord for services by him within a period of 90 days. Next, 3A, the rent compensation may be revised only if there has been an increase or decrease in the market value of the premises. Such revision shall be made on an application made to the collector by the landlord in the prescribed manner, provided that no application until after the expiry of a period of 5 years from the compensation for the last phase.
This is for change in market value and all that.
Even
that's not applicable here.
The unhappiness of an amount which you have already taken That is inequitable. Just because I am a state, you're not happy. You've taken the money, enjoyed over several crores, 3 crores, over 3 crores, over a period of time they have taken.
Yes.
After enjoying the money, commission is saying without any provision of law, I'm not happy. That is not equitable. That is not perhaps even permissible under law. What is permissible as far as division goes, is embodied in 14A. Clearly, if there is market fluctuation, within 5 years, you have to come, all that. There is no, and Justice Standard says you do it in accordance with law. Kindly see, my lord, what the portion they are relying on. Page 68. He's taken the money. He has encapped the check.
Will you take instructions or whatever, because section 11 doesn't come to your aid.
Lord, may I put this way, my lord? My lord, section 11, my lord, comes to my aid because, my lord, now this is a new assessment which has been done for the period subsequent to
The new
89.
assessment has been considered in the earlier writ petition.
No, no. My lord, the earlier writ petition as filed was with regard to, my lord, the lapsing of the acquisition proceedings, nothing beyond that. It was only when this honorable court held that this proceedings has lapsed and held the corporation to be in illegal occupation, and there was a direction for assessment which had been done pursuant to the order by the court, then that assessment could not be deemed to be an agreement, my lord. Because for an agreement, there must be a consensus ad idem. They have paid me an amount in terms of the order of the court. While accepting that, my lord, I had voiced my grievances. And there was a caveat that I am accepting this subject to the rights and prejudice, without prejudice to my rights and contentions. So, my lord, now let's pause here for a moment, my lord. Suppose, let me put it this way. An assessment is done by the collector. If a person is aggrieved by it, he must have a forum. Let me for once take, my lord, that this statute doesn't have one. Though, my lord, I'd say I'm still governed by 11. Let me for one pause here for a moment and say the statute does not have one. Even then, my lord, I'm entitled to invoke the writ jurisdiction of his court, since I have no other alternate remedy.
No, the maintainability is not in issue at all.
Yes, my lord.
What is the provision for enhancement?
I'll tell you, my lord. I'll come to this, my lord. So, my lord, the provision of enhancement is under 14, under certain specific conditions, and my lord, if my lord takes it, revision is increase and decrease in market value of premises. So, but those are with regard to revision as concerned. Had I been before my lord with regard to the assessment made prior to 89 or to 89, I could have invoked these provisions and come. I would have said, see, my assessment was till 89. Now I want a revision of the assessment till 89. Suppose I was getting 15. I should not be getting 15. I should be getting 18 for the period up to 89. But not here today, I'm on a different footing altogether.
Even after the period from 89 till delivery of possession, that period has been taken into consideration by the coordinate bench.
No, my lord. Because
see the language.
My lord, kindly seize, my lord. My lord, there are two issues, my lord. There are two orders. One is the writ petition, my lord. One is the contempt.
No, the writ petition itself.
Kindly seize the writ petition, my lord.
My attention is drawn to section 11.
Yes.
So this mechanism, section 11 was taken into consideration by the court.
No, my lord.
In taking into consideration,
89.
the paragraph comes.
Yes, my lord.
No, not 89.
Yes, my lord.
Nothing to, no, not at all.
Kindly seize, my lord.
Midnight of 1992 till the property is delivered.
Yes, my lord.
This period.
No, my lord.
After 89.
My lord, kindly seize, my lord. It is brought to the notice of this court that an arbitrator was appointed by this court for ascertainment of the compensation required to be paid to the petitioners for requisition of the premises, and the said compensation was determined as far back as in 1989.
So that part is over.
So till 89, then this goes on to say, my lord, my attention is drawn to section 11. So, my lord, the reason why this honorable judge said this was that this, in terms of section 11, up to 89, an exercise had been completed. Kindly, my lord, kindly thereafter, my lord, kindly seize, my lord.
Since thereafter no revision was made.
Yes.
Right. Then section 11 In terms of section 11, the state government was directed.
Kindly cease. This court therefore directs state government to take steps for revision of compensation for the period from the midnight of 31st.
This is in terms of section 11.
If I pause here for a moment, if I say, if this was in terms of section 11, so there has been adjudication, where do I go? Which is the forum I approach? If that is the case that I am called upon to meet, if there has been assessment in terms of an order passed by the court and I'm aggrieved by it, where do I go?
Insofar as the act is at present, you can approach for increment only in
again, probably
not beyond that.
Probably I'm not articulate enough.
Well, I think take some time and consider this and come back, because I am not really convinced.
So I come back to this.
This 14 revision, they have already availed of kindly please market-based fluctuation. Kindly please page 37 months. This is there. After Justice Tandon's order, we rely on that and we write to you that because of inflation in India.
Yes, that's what I say.
So from the revision.
Precisely.
This is their calculation, their own calculation.
Have you considered this?
No. Show the reply.
Where is the reply?
Kindly show the reply,
After this,
11th October 2018 letter, where is the reply to this?
Yes.
This affidavit is regard to the contempt.
No.
11th October 2018.
Yes.
Now, this is my reply. 29 March 2019.
Where is
it? This is page 40. 40. Terms of the order passed direction for commencing services pursuant to the order hearing was called on 12th October and which you duly attended. Now,
this is my letter,
Yes.
This is my affidavit filed in the content of the
Yes.
So subsequently, when I have said that I have said,
Where is the order of consideration?
the order of consideration.
Yes.
Page 49.
This is in terms of the Honorable High Court's order.
This is page 49. View of your exercise has been made last paragraph to ascertain the amount of net compensation for the period 2019. Here it may be mentioned that the district judge was appointed arbitrator by order of 2002 to determine the compensation. Non-district judge sole arbitrator passed a decree fixing per month for all the three portions of the same. Then while calculating the of 50 has been accepted as the base price.
Yes.
From the first division of rent 20%.
Yes, in the last paragraph, it is stated that your letter has been considered.
Yes.
Calculation comes to 3.something as on 31st January.
Kindly cease. No, fine.
Now, this not pursuant to this, we have payment.
Yes.
That is not in dispute.
Yes, so they have received. They have accepted.
Without prejudice.
They have.
Without prejudice, they have received.
Kindly permits me to show it.
Page 52. Calculation and outstanding compensation. Suggestions were submitted for you for getting an authentication during the state calculation. Was considered.
I would request you to find out a way, take necessary instructions on this.
Kindly takes page
Because
70 for once.
prima facie, I'm not really convinced.
Kindly takes page 70 for once.
74?
70.
70?
70. This is This is subsequent to Justice Tandon's order, my lord, and the payment, where I've said, see, I am not satisfied with your assessment, so kindly appoint an arbitrator under page 72, my lord, sees. Is the response to this which is being called for. When I say that I am not satisfied with the assessment so made by you, I am entitled to invoke section 11.
Demand justice.
Absolutely so. Because I had knocked your doors. I didn't find favor.
Will you consider this application upon hearing the petitioner? Will you consider this application upon hearing the petitioner? Yes.
I'll take instructions, my lord. Just my client is here. The client is here, my lord. Well, I understand the predicament of all this, my lord.
Absolutely. No, that's fine. You take, yes. I'll fix it sometime. I'll give you a short date. Because rather than dismissing it as a whole, I think it will be better if I send this for consideration.
May I say this once again? My lord, this end exercise will be repeated in 2 months' time. End exercise repeated in 2 months' time.
You will have an opportunity before the authority.
My lord knows it better than me. What is the opportunity? I need to take that. Keeps it. Yes. Not at my instance, certainly.
You want to come back?
Come back next Thursday, my lord.
WP that order. Heard main matter. Heard learned counsels for the parties. Paragraph. Let the matter appear under the same heading. 8. There are a lot of matters. 22nd in that case. 22nd February. Urgent certified website copies. If applied for the only the relevant. Yes.
I'm so grateful.
Otherwise, I have to pass a reasoned order.
Because today I must have a forum where I'll ventilate my grievances. If it's not in the statute, I have the writ court. If I have no other remedy, the writ court is the only remedy I have. Because besides.
Once an arbitrator awards similar after an award, would that
89.
Compensation because revision was available, they are exhausted that provision and they must accept it. Taken the months.
Yes, because of the illegal occupation of the corporation.
What she says is prima facie of some substance. So I'll not express further comments on this, but then please come back.
I will come back. I'm grateful.
Oh,
Lord, I appear on behalf of the petitioner.
yes.
And
For the
she
respondent, I'm
recalls-
praying for a short Passover.
Passover is not possible in this case. I'm sorry.
Actually, the single counsel was
Are you
here.
ready?
Lord,
No,
my learned friend can take my notes, my lord, and thereafter his senior can
senior counsel was here. He's gone to.
My lord, it is that matter your lordship recalls. This is, my lord, an application under section 74 of the Indian Trust Act, my lord. Now, my lord, this
That
relates.
appointment of trustee, right?
Yes, for appointment of a trustee.
There was an interim order, no?
There is an interim order.
It's extended till 29th February. So I'll just fix it because he is in some predicament today. Let there be a date before the 22nd. You're enjoying an interim order.
My lord,
So no apprehension.
I understand, my lord, and I fully appreciate. But thing is, my lord, the term is for 5 years. Already 2 years have passed, my lord. In fact, we are now, my lord, in 2024. This is still 2020, 25. 27. Oh. 2 years have almost lapsed, my lord. So, my lord,
On 22nd.
as your lordship please.
Well, let us not embarrass him because his senior is not there.
My lord, my learned friend can take note of, my lord, my argument, and thereafter, because his senior was here.
Substantial arguments, I remember.
Yes.
Maybe it would have been completed today. You don't have much more to say, I think, on this.
Not much, my lord. I'll just indicate 2 points, my lord. my lord, my right, my lord, to be appointed as a trustee. And my lord, secondly is, my lord, their objection cannot be, my lord, considered in view of, my lord, the law laid down in the Indian Trust Act. And, my lord, even if it is considered, my lord, without prejudice to my rights and contentions. Okay, actually. So, my lord, my learned advocate record is here.
22nd. Even I was expecting that he'll be here for the hearing. On prayer of you're the respondents. Respondents, the matter is adjourned. Paragraph, let the matter respondent, just check this. Let the matter appear under the same heading on 22nd February. Please be ready on the next occasion. Can be dealt with on the next.
কিছু বলছি পরের দিন